All right, good evening, everybody, and welcome to the Boise City Planning and Zoning Commission public hearing. A few things to start out with for tonight's proceedings. Everyone from the public entering the hearing virtually has been automatically muted and cannot speak. As the item you're interested in comes up for discussion, you will be called upon and unmuted, excuse me. There is a chat function in Zoom. This is not part of the record and should only be used if technical difficulties arise. Our procedures for public hearing begin with a presentation from the planning team. Then we'll go to the applicant and then the representative of the Registered Neighborhood Association, followed by questions from the commission. After that, we proceed to public testimony, starting with those who are in person, then those who signed up on the sign-up sheet in advance, and then anyone else who raises their hand virtually. If you are attending through your telephone, you can type in *9 to raise your hand. Each member of the public is allowed up to 3 minutes for testimony. We are strict with this time as it is limited in state code. Finally, the applicant is allowed 5 minutes for rebuttal, after which the hearing will be closed and the commission will deliberate and render a decision. Mr. Chair, you have the floor.
Thanks, Crystal. Good evening. We are citizen volunteers appointed by the mayor and approved by the city council who make final decisions on conditional use permits, variances and appeals, and recommendations to the city council on subdivisions, rezones, annexations, and code or comprehensive plan amendments. Any decision made tonight can be appealed to the city council, provided that the appeal is filed within 10 days of this hearing. In order to file an appeal, you must have given written or oral testimony at tonight's meeting. That's why it's important to give your name and address when you testify tonight. We utilize a consent agenda. This means that if the applicant agrees with the staff report, and if there is no public opposition, the item will be placed on the consent agenda. All items that are placed on the consent agenda are approved with one motion without further public comment. For items not on the consent agenda, we will hold a full public hearing in the order just detailed a few minutes ago with staff, applicant, neighborhood association, and then the public testimony. Thank you all for attending tonight. Will the clerk please call the roll?
Stead. Schaefer.
Here.
Squires.
Here.
Blanchard.
Here.
Moore.
Here.
Gillespie.
Here.
Danley.
Here.
Mooney.
Here.
7 present, 2 absent.
Okay, thank you very much. All right, a couple of things. Looks like we have a few items that are eligible for consent tonight. We'll start there. Without objection, I will place the meeting minutes from our meeting on April 4th, 2022, and from May 2nd, 2022 on the consent agenda. And then one other note, item number 1 has been withdrawn. That's PUD 21-55 at 2189 West Boise Avenue. That item has been withdrawn, so we will not be hearing that item tonight. And then moving on into items eligible for consent. The first one on our agenda is item number 4. That is CUP 22-11 Lamar Outdoor Advertising of Idaho. The address is 8935 West Emerald Street. This is a conditional use permit for an off-site advertising sign on 0.69 acres in an M1D zone. Is the applicant with us this evening? Great. I see Mr. Miller has a hand up online. Mr. Miller. Not coming. Have a little technical difficulty, it looks like here.
Yeah, apologies. It's not letting me switch into panelist.
Okay. Okay, terrific. I see a note here from Mr. Miller, who is the applicant, that he is in agreement with the conditions of the staff report. Is there anybody in attendance this evening that's here to testify in opposition to this item? Okay, no hands up in person or online. So we'll go ahead and place item number 4 on consent. The next one on our agenda, item number 5, similar project, CUP 22-10 Lamar Outdoor Advertising of Idaho. This project address is at 2840 South Cole Road. This is also a conditional use permit for an offsite advertising sign on 2.78 acres in an M1D zone. Mr. Miller, are you also in agreement with the terms and conditions of this staff report for this item? And if you can just answer on the chat, that'd be fine, I think. Terrific. Let the record show that he is in agreement with the staff report. Is there anyone in attendance this evening that's here to testify in opposition to this item? Okay, again, no hands online or in person, so we'll go ahead and place item number 5 on consent. And we have one more item. Okay, item number 10. This is PUD 22-37 Bronze Bow Land at 1501 North Garden Street. This is a modification of a conditional use permit for a planned residential development comprised of 3 single-family homes on 0.42 acres in an R1C zone. Is the applicant with us this evening? Mr. Schneider, are you in agreement with the terms and conditions of staff report? Yes. Terrific. And is there anyone here in attendance this evening that would like to testify in opposition to this item? Again, item number 10 at 1501 North Garden Street. Okay, terrific. No hands up online either or in person. So we will place item number 10 on consent. I believe that does it for our items eligible for consent. I will now entertain a motion.
Mr. Chair,
Commissioner Blanchard.
I move that we place the minutes from April 4th and May 2nd, as well as item number 4, CUP 22-11, item number 5, CUP 22-10, and item number 10, PUD 22-37 on the consent agenda.
Second.
I have a motion and a second to approve the consent agenda. Any further discussion? Okay, very good. Will the clerk please call the roll?
Schaefer,
Aye.
Squires. Aye. Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Stanley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay. Very good. Thank you all. Next, we've had a request to amend our agenda. We've had a request to move item number 11. That is CVA 22-8, BGA Planning and Design, up to item number 3 on our agenda this evening, or the third item we hear. I will entertain a motion. Commissioner Danley.
I make a motion that item number 11, CVA 22-00008 be moved from number 11 up to number 3 on tonight's agenda.
Second.
Got a motion and a second. Any further discussion? Okay, very good. Will the clerk please call the roll? Aye.
Squires. Aye. Blanchard,
Aye.
Moore.
Aye.
Gillespie,
Aye.
Stanley.
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay, great. That does it for all of our initial housekeeping tonight. We'll dive right into our agenda. The first item up is item number 2. That is CAR 22-4, Andy Thompson Construction Incorporated. Project address is 2576 and 2623 North Linda Vista Lane. This is a rezone of approximately 1.86 acres from R1B to R1C. First, we're going to hear from staff, and that is Ms. Jessie Lyle, who I believe is online.
I am, thank you.
Hey, Jessie.
All right. Can everybody see me and hear me?
Yes.
Okay, thanks. Good evening, Mr. Chair, members of the commission. Item CA 2-4, an application to rezone 1.86 acres from R1B to R1C. The subject property is located at 2576 and 620 North Linda Vista Lane. The area contains mainly single-family housing, and the surrounding area has piecemeal R1B and R1C zoning, R2 zoning to the south. The future land use map has the site designated as suburban, with in which the R1C zoning designation is allowed. Other zones allowed within the suburban designation include open lands, office, and other residential. The planning team finds that the R1C zoning is appropriate for the subject properties as the proposed density is similar to the surrounding area. While the applicant has not submitted any other applications with the rezone, the conceptual site plan shows the applicant keeping the existing duplexes at 2623 Linda Vista and adding 2 additional duplexes on site, as well as adding a cottage style development to 2576 Linda Vista. Any additional development will require additional PUD applications. There have been public comments received concerning density, traffic increases, and potential parking and safety concerns. While zoning designation of R1C would allow for additional units in the neighborhood, traffic impacts, safety, and development compatibility will be assessed at the time of development application is received. Additionally, the applicant would be able to be required to provide parking on site. In conclusion, the planning team recommends approval and sees no impacts to the surrounding properties. And I will stand for questions.
Okay, thank you, Jesse. Next, we'll hear from the applicant. Yeah, come on up, please.
Hi, I'm Andy Thompson.
Can you start with your address too, please?
1625 South Helen Street, Boise, 83705.
Great, thank you very much. You'll have 10 minutes.
10 minutes, okay.
Yeah. You don't need to use all of the 10 minutes.
Thank you. Thank you for your time. Thank you, Jesse, for basically saying exactly what I would have said anyway. So I think that's all I need. Like she said exactly what I would have said. So if there's any questions, I'm happy to field those.
Okay, sounds good. We'll sit tight on questions for 1 minute. Thanks. Okay, do we have a representative from the West Valley Neighborhood Association with us this evening? Okay. Let me check online real quick. Okay, I guess we'll go ahead and just bring this item to the commission for any questions to pose to staff or the applicant.
Well, we have to have one question.
Good call. Commissioner Gillespie, please.
So I'm sorry, what was our staffer's name?
It's Jesse.
Jesse. Sorry, Jess. I'm just trying to get warmed up here tonight. Jesse, it looks to me from this map that these parcels abut other R1C zones and that there's R1C zones all around, really both of them. Am I reading that correct?
Mr. Chair, Commissioner Gillespie, yes, that's correct. There's R1C all in the area, but there is R1C abutting each parcel on multiple sites.
All right. Thank you very much.
Yeah. I guess I got one for the applicant, Mr. Thompson. Can you come back up here just real quick so we can get you on the record? Just want to make sure that you've read the staff report, you're comfortable with all the terms and conditions within that staff report.
Yes,
Okay.
straightforward.
Great, very good. I think that's it.
Mr. Chair.
Yeah, Commissioner Blanchard. I'm sorry,
Mr.
Mr. Thompson, you might want to sit tight one real
Quick
quick.
question for the applicant. This is just a simple rezone, correct? Like we're not hearing a proposed project tonight, correct?
The owners wanted to move forward with the project, but they hadn't really solidified it. So I told them like an easy way to do it is to get the rezone done so that you can like know exactly what you're up against. And so we don't have to come in front of you guys after the whole designing and then kind of the cart before the horse thing. So I said, well, get the rezone done. They can do their readings. It takes, a lot of time out of the process. So as soon as they do get their PUD, which they'll have to apply again and go through the whole process, but it's a commission level rather than going in front of the city council.
Okay, so just want to be clear to everybody that all we're doing is determining whether the zoning is appropriate. We do not have a project before us tonight.
That's correct. Just
Okay.
changing the color on the map.
There we go. Thank you.
Okay, any other questions? Very good. All right, thank you, sir. We'll go ahead and open this up for public testimony. If you're here in person to testify, please come on up to the podium. Or if you're online, please go ahead and raise your hand.
Mr. Chairman, do you
Yeah.
have the sign up sheets?
Oh, thank you, sir. I do have a sign-up sheet. I got Mark Andrews and Andy Thompson. I'm assuming Mr. Thompson, you already spoke, so we're good there. Mr. Andrews?
Nice to meet you. Mark Andrews. I live at 2640 North Linda Vista. Okay.
Yeah, you're good. Yeah.
Yeah, 2640 Linda Vista.
Okay.
Lane, Boise. My concern is a couple of things. Traffic in the area. That street is not built for big traffic or fast traffic. It's a 20-mile-an-hour street. Another thing, these are two-story. Where are some of our elderly people going to live without stairs going up? This town's getting overcrowded with chicken coops, as I call them. Most of these houses could fit in my garage on my property. It's just a poor way of organizing our city. I know it's a great tax opportunity for everybody, which is good. But my thought is just to calm it down a little bit. Let's think about our city before we think about cramming more people into it. On it. I've lived here all my life, so I've seen what has happened, what's been the mistakes. Unfortunately, the mistakes still keep happening. But that's my thought on this process. So, any questions? Oh, any questions?
Nope, none for us. Thank you. It's just your turn for testimony. So,
Okay,
yeah,
thanks.
thank you. Okay, anyone else that'd like to testify on this item tonight? Okay, very good. We'll go ahead and close the public hearing portion. Mr. Thompson, this is your opportunity for rebuttal. The applicant always has a few minutes for rebuttal from public testimony. Would you like to make any final statements or rebut anything?
Again, we're not increasing traffic just yet. We're just changing the zoning. So he has a valid point, but that's a matter for another day.
Okay, very good. All right, thank you all. We'll go ahead and bring this item back before the commission now to render a decision. Again, this is CAR 22-4, a rezone from R1B to R1C of 1.86 acres.
Mr. Chair,
Commissioner Blanchard.
I recommend approval of CAR 22-04 with all the terms and conditions as outlined in the staff report.
Second.
I have a motion to recommend approval by Commissioner Blanchard and a second by Commissioner Squires. Commissioner Blanchard, would you like to start us off on a little discussion?
Thanks, Mr. Chair. Yeah, with sensitivity to Mr. Andrews' testimony here, we're hearing is the rezone, whether it's appropriate for this area to go from R1B to R1C. So it's pretty established in the record that there's R1C all surrounding it. So it is appropriate that we rezoned that. We don't have a project to look at tonight. So we don't know what they're going to put, and that will be, again, as the applicant stated, a debate for another day, just to see what they're going to put on there. And we'll have plenty of opportunity to review that planned unit development when and if that comes before us. So I think it's pretty clear that it is appropriate to rezone this to R1C.
Thank you, Commissioner Blanchard. Any other discussion?
Mr. Chair,
Commissioner Squires.
I would just echo what Commissioner Blanchard said and just state, I do like the concept plan, however. I know that's not what we're here to talk about tonight, but I find it creative and would love to see something similar to this when you do come back. Thank you.
Okay, thanks, Commissioner Squires. Any other comments? Okay, very good. Go ahead and call the roll here. We've got, again, this is item number, sorry. This is item number 2, CAR 22-4 at 2576 and 2623 North Linda Vista Lane. We have a motion to recommend approval by Commissioner Blanchard and a second by Commissioner Squires. Will the clerk please call the roll?
Schaefer,
Aye.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Stanley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Thanks, everybody. Up next, previously item number 11, now item number 3, CVA 22-8, BGA Planning and Design at 1302 North 24th Street. This is a variance request to allow a garage addition to encroach into the side street setback on approximately 0.24 acres in an R1CH zone. First, we're going to hear from staff, and that's Sabrina Mortensen.
Good evening, Mr. Chair, members of the commission. The item before you is a request for a variance to encroach into the street side setback for a garage addition on 0.24 acres located at 1302 North 24th Street in an R1CH zone. The subject property currently contains a single-family home, an attached one-car garage, and a detached two-car garage. The applicant requests to expand the attached garage to improve accessibility for a wheelchair-bound resident of the home. As proposed, the garage would encroach 20 feet into the required side setback, and the eaves of the garage would extend over the property line. The applicant's letter of intent cites design guidelines for residential historic districts and the presence of mature trees on the site as justification for the variance request. However, the historic design guidelines are generally applicable to all residential properties within the surrounding historic district and therefore do not constitute an exceptional circumstance. Although the design of the proposed garage complies with historic preservation requirements, the proposal conflicts with policies of the comprehensive plan, which encourage the use of complementary setbacks and minimizing the placement of garages along the block face of residential streets. Furthermore, the proposed addition would encroach into the clear vision triangle where the where the existing circle drive intersects with Reidenbach Street, thereby obstructing motorists to use and increasing the potential for collisions to occur in this location. The planning team received late correspondence from the property owner detailing the medical diagnoses of one of the residents of the home and outlining the provisions of the Fair Housing Act and ADA. Examples of past variances which have been approved by the city were also included. While the ADA and FHA require the city to make reasonable accommodations to afford persons with disability an equal opportunity to enjoy their dwelling, the requested 20-foot encroachment is substantial and there are other options that could be pursued to provide the wheelchair van loading area. Furthermore, the approval of past variances does not set a precedent for the current application as each property and situation is unique and must be evaluated individually. In conclusion, the planning team recommends denial of the variance and recommends that the applicant provide the wheelchair van loading area by remodeling the existing detached garage or utilizing the existing driveway in front of the home. And I will stand for any questions.
Okay, thank you, Sabrina. Next, we'll go ahead and hear from the applicant.
Hello?
Yeah, Brian's on Ryan. Oh, okay. Okay.
Can you hear me?
Yes, we can.
Okay. I'm just going to share the screen if I can.
And sorry, Mr. Gilbreth, you can start with your name and address for the
Sorry. Brian Gilbreth, 1711 North 11th Street, Boise, Idaho, 83702.
Okay, thank you.
Thought I had it. Oh, boy.
There we go.
That's Can you see my screen?
No, we cannot.
Okay, I'm sorry.
Should be a green button. It says share screen.
Yeah. Apologies. Oh, boy. Okay. Apologize here. It's not allowing me to share the screen here.
Now we can see you.
Okay. It's not allowing me to share my screen. I submitted some documents that pretty much cover what I was going to show on the screen anyway. We just walked through. Thanks for taking the time to hear our comments in support of the granting of the variance. Your comments indicate that the hardships and exceptional circumstances provided within the proposal do not justify the variance request for an addition into the existing attached garage to encroach 20 feet into the street side setback. And we're in disagreement with that, obviously. And we do believe that there are hardships and exceptional circumstances presented, and they do justify the variance request. The current garage was constructed by the same family who's residing there now in 1937. It's located 6'6" from the property line and is 20 foot from the street. We're asking to add 5'6" to the south end of that garage so that it would end up being 1 foot from the property line, essentially. The eave is not, before we were showing the eave extending into over the property line, but we pulled that back in so the eave would not be extending over the property line. We've reviewed many suggested alternatives for placement of the garage, and in each one of those, there's been issues. One of the recommendations from staff was to create a breezeway from the existing detached garage at the back of the property. And by doing that, it essentially bisects the site in half, does not provide any weather protection for the person in the wheelchair. And it also is a 42-foot distance to travel. So that's not really a legitimate alternative. Placing the garage between the existing house and the existing detached garage, we would have to remove trees in that area. And according to the design guidelines of historic districts, that's not doable. We wouldn't be able to remove those trees to be able to do that. Essentially, another suggestion was to add a garage that was accessed off of the alley. There's no room to do that. In order to add a garage onto the alley, off of the alley, we would have to, in order to get a turn-in distance beyond the existing detached garage at the north, we would have to lose, there's a CMU wall all along the backside of the fence. It's about a 6 foot high CMU wall with a garbage enclosure. We would have to, in order to stay within the setback line on that side, would have to pull it far enough into the site to where it was butted up against the back of the house and essentially lose half of the back bedroom in that house. We don't feel that the proposal conflicts with the principles of the comprehensive plan because this garage that's existing on the house right now is part of the established streetscape. And as you're cited, to provide garage access through existing alleys, minimize the placement of garages along the block face. Well, this house has always historically had a garage. We believe that the removing of the garage function from that area that it is located in this particular home would not be in the spirit of the comprehensive plan. Again, it's always had a garage in the front. It's access from the side. That drive is the same. We don't agree that it's going to have any effect on the vision triangle. I don't know. I saw on the illustration that the vision triangle out of the garage there, the driveway is existing, it's not changing, and the vision triangle should be shown down at the curb where the driveway enters the street, not back up at the property line where we were next to the garage. Anybody driving up there, in the garage is well off the street. We're 15 feet off the street there. So beyond the site related hardships that we've noted, there's also a hardship that the Tillman family has endured with regards to performing any improvements on the house for about the last 20 years. Since 2002, the property was considered to be of contributing status, and therefore the family was not able to pursue any changes to the property due to its status. Fortunately, we were able to meet with SHPO, and their investigation concluded that the property was erroneously categorized. The project has had its historic classification changed from contributing to non-contributing and has also already been approved for certificate of appropriateness. While we support the efforts of the Planning and Zoning Department and understand the importance of the guidelines, we feel that this project should be granted a variance based on what we feel are the constraints presented by the site itself, along with the design guidelines, especially with regards to existing mature trees. And we do believe that the granting of the variance will not be in conflict with the spirit and intent of the comprehensive plan. As noted in other applications for variance, policy 7.1.4.5 encourages development of residential units that are accessible to handicapped persons and adaptable for conversion to use by handicapped persons. We feel that a safe, connected, accessible garage does assure safe access to transportation and to the neighborhood in general. The variance to allow encroachment into the side yard setback for construction of a garage promotes and establishes a physical framework of development which is in keeping with the character of the North End neighborhood. There also exists personal hardships from the owner's requirements for accessibility and safety issues that I would like to turn the time over to the Tillman family to discuss. Hello.
Good evening, John Tillman, 1302 North 24th Street. Temporary address is 9345 West Levitt Street in Boise 83704. Thank you, P&Z, to let us respond to our variance request and to hear our concerns. We hope you will support Mayor McLean's directive to support and care for all people of Boise to ensure truly a city for everyone, and everyone needs a safe place to live. It is well established by the medical community that remaining in the home is essential to the highest quality of life as we age. My father built the house on 24th Street in 1937. Due to our changes in the original footprint, the house was classified as non-contributing. It also has a certificate of appropriateness. Our remodeling request has the full support of the neighbors, the North End Neighborhood Association, and the Boise City's Historic Preservation Commission. It has been an extremely stressful time for us. As you know, my wife has progressive multiple sclerosis, seizure disorder, congestive heart failure, and impaired mobility. She uses a walker, orthotics, and will eventually be in a wheelchair. We need our attached garage to be handicap van accessible. We have 3 doctor's orders and a physical therapist's evaluation that's in the file. The house itself is creating a hardship for my wife to live there. That's why we're not living there now. The remodeling is the only way to provide year-round safe access into and out of our home in inclement weather and emergencies. After evaluating all of our alternatives, we have proposed the best solution, and while preserving all historic trees, character of the home, and meeting variance approval criteria. We have a unique lot where we own 2/3 of the block and there is no sidewalks, or will there be? The proposed garage or eave will not encroach on or over the property line and will be 14 or 15 feet from the curb. A clear vision triangle will not be affected. We're approximately 75 feet away from 24th Street. We can see at least a block and a half in each direction and have had no problem since 1937 in vision. There are many residential properties and garages built to the property line in the north end, including several on Reidenbaugh. So we are not setting a precedence for the neighborhood and actually provide more of a buffer than these properties. If you reference a photo of 1301 North 20th, it is on the property line of Reidenbaugh and 20th that I just submitted this evening. We believe we meet all of the approval criteria for this variance. We are preserving all the historic trees of the property. The current property as is provides a hardship for my wife who cannot continue to live there safely without appropriate covered access. Also, there is an exceptional circumstance related to the intended use, as the intended use is that of habitation by the family that built the home 85 years ago and will remain in the family. Granting the variance is not in conflict with the comprehensive plan and will not affect the change in zoning. The house is non-conforming. Granting this variance will not be detrimental or injurious to the public. Per P and Z concerns regarding the eaves encroaching over the property line, we have modified our design to ensure that this won't happen. The ADA, FHA, and Rehabilitation Acts address modifying zoning policies, practices, and variances. Discrimination under the FHA addresses a refusal to make reasonable accommodation in rules, policies, practices, or services that may be necessary to affect such persons equal opportunity to use and enjoy a dwelling and major life activities. According to the FHA, the local government must consider the relationship between the disability of the residents and the need for the requested accommodation. If so,
I hate to cut you off. I hate to interrupt, Mr. Tillman. We are over time. It's been 10 minutes. Can you wrap it up here in another minute?
yes,
Okay.
yes, sir.
Thank you.
If so, the locality must grant the requested accommodation unless it doing so will pose a fundamental alteration to local government zoning scheme or an undue financial and administrative burden to the local government. Our alteration does not pose any of these burdens. There are several court cases that I have submitted in there. I won't bother to go through those at this time. And they've actually, let's see, we ask your consideration. We ask you to consider the information and context we're providing as a more than reasonable approval of our requested variance for an ADA accommodation. Thank you so much for your time.
Thank you.
Are there any questions?
We'll do questions in just a minute. Thank you. First, we're going to check in and see if we have a representative from the North End Neighborhood Association with us tonight. I don't believe that we do. Okay, doesn't look like it. So we'll go ahead and open this up to questions from the commission to staff or the applicants.
Mr. Chair,
Commissioner Moore.
and this is a question for staff. Where were if you have the site plan up, where were the locations of the alternatives that you had proposed in the staff report? The one was the detached garage, but the other one I was a little bit unclear on. Is it just that parking?
Right, yeah, so Mr. Chair, Commissioner Moore, that's correct. So the two alternatives proposed in the staff report would be to provide a breezeway connecting the covered patio to the detached garage here. And the second would be to use this existing circular drive as a loading area.
Mr. Chair.
Please, Commissioner Moore. Yeah.
And so in the case of using that kind of existing area or the parking to encroach due to the van accessibility into the setback, that would be a reasonable accommodation for the city. That would be something that would be potentially accepted by variance. I know parking is usually allowed outside or required outside the setbacks.
That's correct, Mr. Chair, Commissioner Moore. That's an existing driveway parking and loading area, so no additional approvals would be required to use that space.
And Mr. Chair.
Please.
And so if that ADA parking were to be required or to be placed in the detached garage, would there be an option, assuming historic approval, to connect that with a covered breezeway?
Mr. Chair, Commissioner Moore, yes.
Thank you.
Okay.
Mr. Chair.
Commissioner Mooney.
Follow up on Commissioner Moore's question for staff. Could you talk us through the alley load option that would be an option?
Mr. Chair, Commissioner Mooney, yes, that's not an option that I discussed with the applicant. I believe that may have been something that was discussed with other staff previously. But in order to utilize that option, that existing garage would need to be moved a little bit or obtain a variance for the backup space to the alley. So it would take some reworking to utilize that as an alley loaded option.
Mr. Chairman,
Mr. Danley.
question for staff, and I think it's a quick one, but when I'm looking at the schematics of the house, it looks to me like the property line, specifically that fronts Reidenbaugh, where there is no sidewalk. The planter and half of the driveway look to be outside of the property line. And therefore, if ever a sidewalk was to be put in here, because it looks like, at least from a jurisdiction perspective, it's conceivable. And based on the fact that the 24th Street sidewalk is a detached sidewalk and therefore a buffer space in between, I guess the question would be, if that general design were to be wrapped around Reidenbaugh someday, because again, it's conceivable, would the addition of the garage somehow prevent that from occurring?
Mr. Chair, Commissioner Danley, there is approximately 13 feet currently between edge of curb and the property line. So conceivably, an 8-foot landscape strip and a 5-foot detached sidewalk could fit in that location.
Okay, great. Thank you.
Mr. Chairman.
Commissioner Gillespie.
So this is just a technical, I'll phrase it as a question, but one of the challenges we face here tonight, folks, is a variance is forever. It's permanent. It's not contingent on who lives there or what they do or their condition. It's forever. Is my interpretation of how a variance is implemented correct?
Mr. Chair, Commissioner Gillespie, yes, that's correct. Once approved, the variance could remain indefinitely.
Thank you.
Okay, that does it for questions, looks like. Okay, all right. We'll go ahead and open this item up for public testimony. If you're here in person, like to testify, come on up to the podium, please. And if you're online, please go ahead and raise your hand. We'll do the in-person folks first and then move to online after. You testify, please start with your name and address, and you got 3 minutes.
Hi, my name is George Forbes. I live at 1301 North 23rd Street. I wasn't expecting to speak at this meeting tonight, but I wanted to add a few things. One, I've been their neighbors for 32 years now. They talked about their dad building this house in 1937. Their mom lived in it till she was 105. I think it was 100, maybe 102. Great people, great neighbors. One of the things I was debating on is the obstruction, the visual obstruction for turning that corner. And I've turned that corner thousands of times, and there's no way that adding 5 feet to that garage would obstruct any vision and be a hazard. So I debate that totally. Let's see, I made a couple other notes. I think you also said that it was over the property line. I think the architect addressed that, and it's not going to be over the property line. I think they mentioned the vision triangle. And the setback. Setbacks, I believe the main reason for setbacks is for police and fire to be able to access the property. And because it's on the street, there's not that issue at all. So, you know, the setbacks on the alley, all those garages are right on the property line. I don't see any reason why this can't be the same, right on the property line. Yeah, that's pretty much it. I just don't see any reason why an accommodation couldn't be made for this family so that they can live in the house comfortably in their golden years, so to speak. And I would hope that when I come to the council or board planning meeting 30 years from now and I need the same thing, that it would be granted. So anyway, thank you.
Thank you.
Chris Tillman, 880 North River Path Lane. I'd like to first address condition 3, that the variance will not be material detrimental. The garage addition will only add an additional 5 feet onto the existing setback. This maintains 14 feet of open space. It's also noteworthy there's no sidewalk, and I don't believe there can be because there's 3 huge historic trees and we own 2/3 of the block. And I believe ECHD has said in the past that they need our permission to even put a sidewalk in there because of that. In respect to criteria number 1, that there be a hardship or exceptional circumstance, the lot is larger and longer than most in the north end. The lot's actually 2 and takes up 2/3 of the block, and it's almost 200 feet long. This makes the P&Z suggestion unviable to instead remodel the detached garage and create a handicap path to the back of the house. And the front of the house is where the master is. So it's a long, long stretch there. And the 2-car garage opens to Reitenbaugh. It doesn't open to the alleyway. So that makes that an issue as well. And I want to address that. I believe it doesn't conflict with the spirit and intent of the comp plan. Comp plan NEC 15's goals to promote Boise's historic heritage. An approved city case, CBA 15-0048, has a hardship and exceptional circumstance very similar to ours. The attached garage was constructed sometimes before 1945, prior to the adoption of the zoning ordinance, and was approved. I quote, "The garage has not been in use for parking due to its rundown condition and is considered legal non-conforming. Our house was built in 37 and the garage has the same hardship." CUP 16-0105 and there's was approved and reduced the rear and street side setback for a garage conversion and a dwelling addition. I quote, "The expansion is intensification of the north end neighborhood that does not involve new multifamily development, policy NE CNN 1.3. There are several other cases. It encourages infill and encourages access through alleys, but it's not required. CVA 09-0004 was approved in Boise for a person's son who was in a wheelchair. It was ruled to be, and I quote, "not in conflict with the spirit and intent of the comp plan. Policy 7.1.45 encourages development of residences that are accessible to handicapped persons and adaptable for conversion to use by handicapped persons. This case allowed encroachment onto the side yard setback for the construction of a garage and a driveway." I feel, a locality is required to reasonably accommodate a disabled person by modifying his zoning policies. And I know they want to put a little breezeway out front, but in order for a handicap van and do a big covered area, we've looked at that option, and it's going to be kind of more of an eyesore we're trying to preserve the historic character of the home that my grandpa built. So any questions?
Nope. Thank you, Mr. Tillman. Anyone else would like to testify? But you're the applicant, so technically you can't testify. But you will get, we can't actually take any more anything else for the record, and you will have an opportunity to rebut any testimony as well. Is there anybody else who'd like to testify? Okay, and looks like no one online has their hand up. So now, Mr. Tillman, this will be your opportunity to rebut. Sorry for the up and down and the back and forth.
In your packet is a picture. There's a picture.
If you could step over to the mic just so the folks online can hear you, that'd be great. Thank you.
Yes, in your packet is a picture. This is the current garage. There, the fence right here, this fence post is within a couple inches of the property line. From this red line here to the curb is 13 feet. If we go in a foot, that'll be at least 14 feet, okay, of clear vision. There's no obstruction from the front part of the garage to 24th Street is at least 75 feet. We can see a good block and a half in either direction. This garage is in the center of the lot, okay? So even parking here, you would still have clear vision after the 5-foot variance extension. This is 1301 North 20th and Reidenbaugh. It's an old place, but it's right on the property line of Reidenbaugh and 24th Street. Okay. The other thing is if you know the history of Boise very well, Reserve Street, St. Luke's, and the Capitol used to flood. There is a canal about a block and a half from our place. There is a big canal in Elm Grove Park that is overflowed also. And if you look at the front steps here, okay, my dad built the foundation of this house higher than normal. So from the bottom to the top is probably close to 3 feet to ground level flooring in the entire house. And that's why putting a ramp here would extend it quite far out. Now in Snowmageddon or whatever, my wife has mobility problems. She slips and falls. That's all part of the medical record I've submitted to you, okay? She really has severe balance problems. It's difficult for her, and even me now, to walk on snow and ice, okay? And to put a covered portico out there would look terrible. It would look terrible and destroy the ambience of our backyard. And we still have quite a raise. You know, to have it covered, it's just not feasible. And this is the least impact, just asking 5 feet by 33 feet addition and have the whole house conform to the neighborhood design will look a lot better than having ramps. Thank you. Thank you so much. Any questions?
No, not right now. Thank you, Mr. Tillman. Okay. We'll go ahead and bring this back before the commission to render a decision. Again, this is CVA 22-8. And I will entertain a motion. Anything to get us, perhaps a discussion to get us started?
Mr. Chair.
Commissioner Mooney, please.
Mr. Chair, I move that we deny CVA 22-0008 for the reasons stated in the staff report. Regrettably, I think the hardship is there, and
let's sit tight on discussion.
Try for a second.
Yeah, so we got a second first.
Second.
Okay, I've got a second from Commissioner Moore. Commissioner Mooney, you want to start us out with some discussion?
yes, I'm obviously sympathetic to the situation, but I also recognize our role is to apply the code as written. And it seems like the majority of the problems that are identified in the staff report and the opposition is the site issues. And I don't consider that the issue. The issue is there's a setback requirement, and that's just the nature of our code. And it looks to be solvable on the parcel without the unattractive ramps that are being referenced. That's where I'm coming from.
Okay, thank you, Commissioner Mooney. Commissioner Moore?
Sure. I second that. It's a tough one because I do understand the logic and the desire to maintain the architectural integrity of the house. I know how important that is. I think I seconded the motion because I think that the architect has done, based on the elevations that I can see, a good job at integrating some of these covered patios and this addition into the intent of the house and the character that that was kind of already ingrained in this house for so long. So I think that the options presented or the alternatives presented by the city, whether it's the portico out front or the covered walkway from the detached garage, I think based on what I see here, the architect could create something that fits and still complements the house. So I think because of those alternatives exist, I'm in support of the denial.
Madam, Mr. Chairman.
Commissioner Gillespie.
So I'll be supporting the motion. I think the specific definition of hardship that I follow has been elucidated by the Idaho courts, and it's pretty consistently pretty clear that to me, a hardship has to be something endemic to the parcel, a creek, a big cliff, unusual grade. It has to be something in the land itself or very closely tied to the land to be in a sense, a qualifying reason for a variance, or it has to be something very unique about the use. So in this case, this is a flat, large piece of land that the applicant has here. And what's happened is kind of the way the puzzle has been built since 1937 has got them in this position. And I regret that. But this isn't a hardship caused by the land. And to the second point on the ADA and the various federal laws and the reasonable accommodation, I'm not sure that this commission is qualified to, arbitrate what's reasonable and not. In this case, the city and the city legal staff have made a recommendation. Their recommendation seems reasonable to me in the sense that there have been alternatives presented. Again, this is a very big piece of land in the north end. So I'm not persuaded by that argument. And then finally, to my earlier point, I'm very uncomfortable granting variances that depend on some character of the current occupant or owner, because that changes. This variance will be on this piece of land for 200 years. For as long as there is Boise City and a house there, this variance is there. So it is a big deal in that sense. And I think variances are important in the north end, especially to be careful, because we hear this argument all the time that, oh, let's just do it. There's a special circumstance to the occupant and other people have done it. Indeed, they may have, but I'm not sure that it was wise then, and I don't think it's wise now. So I'll be voting in favor of the motion to deny the variance.
Mr. Chair.
Thank you, Commissioner Gillespie. Commissioner Danley.
I am a bit on the fence right now, and I'm leaning towards supporting the motion, but I'm not sure I'm there yet because I'm getting particularly hung up on exactly the word that Commissioner Gillespie pointed out. That's part of fair housing and is also part of ADA, and that's reasonable accommodations. And working in the realm of ADA that I do, I know that, for example, it's not specifically, and you can find this in the wording, it's not even necessarily about the metrics only. It's also the spirit of ADA. And that gets lost in the discussions about ADA a lot. But that does matter. And so when we look at this property, I look at it and I think, well, one alternative detracts from the historic preservation notion that we have and we value. Okay. Another one takes away the mature trees in the city of trees, which we value. Okay. The other one requires ADA ramps to go up into the entrance of the home. I can point to you a ramp over 100-foot road that has 800-foot ramps to get up to the top because of the restrictions of ADA, and 800 on the other side. So therefore, an 800-foot crossing requires 1,700 foot of linear distance because of the metrics piece of it. So when it gets into the reasonable, the reasonableness, if you want to call it a reasonable test or what have you, of federal housing law, does this get to that point? Does us accommodating a 5-foot variance, especially in light of some of the other circumstances that were pointed out that may sort of conflict with other objectives of the city, does that get to the reasonableness of this application? I'm close to saying that, but I also understand Commissioner Gillespie's point that this is a decision that's sort of made in perpetuity. So just throwing that out there for now.
Okay, thank you, Commissioner Danley. Any other discussion or comments?
Yeah, Mr. Chairman.
Yeah, Commissioner Gillespie. Yeah.
I have a sort of a comment back on Chris's good comment, and which is I'm not trained, or I haven't read, or the code doesn't contain any, substantive language about the ADA or the FHA. And so I'm left as an amateur practitioner, right, to rely on the advice of the city staff and the city lawyers with respect to those federal statutes. I'm here really to interpret the code, the code that this commission operates by. And I think on that matter, I have a kind of a hard definition of what a hardship is. It has to be part of the land. And again, that's what I look to is the city code. I totally get comments about FHA and ADA. I just have to rely on the city's opinion at this point. Thank you.
Mr. Chair,
Commissioner Danley.
if I may just follow up on that, it's interesting because I completely understand that argument. I also know that this same body makes decisions on cell towers and halfway houses, for example, and we are not allowed to make decisions that trump federal law, right? In those instances, we're told as a local body, we can't deny certain things because of federal law. I'm just saying that it's not always our code that necessarily carries the whole bucket of water there.
Yeah, Commissioner Gillespie.
Mr. Chairman, but Chris, in those cases, we're relying on city staff, which has legal staff, to tell us in the staff report that interpretation of various federal laws. So you're correct. We talk about cell phone law and all that other stuff,
right?
But we're not ourselves sort of creating it, the analysis, if that makes sense.
Mr. Chair.
Yeah. Commissioner Mooney.
I guess we didn't talk much about alternatives. Commissioner Moore opened up questions at that, and I asked to follow up on the alley load. But this appears to be a pretty significant remodel. We're removing an interior courtyard. There's a significant interior remodeling going on. I'm just a layman looking at the site plan, thinking there's a way to place a garage and comply with all the code requirements.
Thank you, Commissioner Mooney. Any other comments from this side of the dais?
Mr. Chair,
Commissioner Squires.
I'm just going to say I'm on the fence as well. I am for the exact same reasons that Commissioner Danley was able to express much more eloquently than I could. I know enough about ADA to be dangerous, and I've been trying to figure out how to apply that to this project in light of the project before us. This is tough. I don't know where I'm going to come down.
Yeah. All right. Well, I'll sound off real quick. I'm also on the fence, and I'm tending towards siding with the motion. And I think, as Commissioner Mooney said, regrettably, I sympathize with the situation. I appreciate the history of the house, the ownership, and the care that you've all taken with the property. But I also see where I agree with Commissioner Gillespie's comments regarding, hardships. And I tend to have the same mindset as he does as far as what constitutes a hardship. And I also agree with Commissioner Mooney when I was looking over the plans that this is an extensive remodel. And I do think with a large, relatively flat or flat parcel, that there's an opportunity here to get the garage closer to the main home. So again, regrettably, I sympathize with the circumstances, but that's where I'm coming down as well. So unless there is any other comments, I think I'll go ahead and call the roll. Again, this is CVA 22-8 at 1302 North 24th Street. We have a motion to deny the variance request by Commissioner Mooney and a second from Commissioner Moore. Will the clerk please call the roll?
Schaefer,
Yes.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Danley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
No, I'm sorry, sir. With that, the item is done for tonight. Should we take a quick break? Yeah, take a time out. Okay, we'll take a quick 5-minute break. We'll be back at 7:13. Okay, welcome back, everybody. We'll carry on to our agenda here. Now, up to original item number 3, CZC 21-00291, Richard Wilmot in Chrysalis Architecture and Planning. The address is 6621 West Ustick Road. This is an appeal of a design review approval to construct a 17-unit multifamily development in a C1D zone. Again, this is an appeal. We're going to hear from staff first, then the appellant, then the applicant. And we're going to hear from Caitlin Manouge with staff first, please.
Thank you, Mr. Chair and members of the commission. I'm Caitlin Manouge, Design Review Planner with the Planning Division. And this is an appeal of a Design Review Committee's approval of CZC 21-00291, a 17-unit multifamily project at 6621 West Ustick Road. At the March 9th, 2022 Design Review Committee hearing, the Design Review Committee denied an appeal and upheld the administrative approval of the application, finding the project complies with all zoning ordinance and design review standards and guidelines. On March 18th, 2022, Dwayne Mitchell appealed the Design Review Committee's decision to deny the appeal. The property is located on the south side of Ustick Road in a C1D neighborhood commercial with design review zone. This area contains commercial uses as well as surrounding single-family and multifamily uses. The project includes demolition of the existing Euro House building on the north to be replaced with a new 2-story multifamily building with 10 units. And the building to the south will be retained and a second story will be added to provide 7 residential units, resulting in 17 total units in the project. The appellant provided a number of grounds for appeal. First, that the applicant didn't follow the required procedures in regard to the neighborhood meeting. Typically, a multifamily project in this zone would require a planned unit development, which would require a neighborhood meeting and P&Z public hearing. But because the applicant is providing income restricted units, the project is less than 25 units total, and it is located on an arterial roadway, the project qualifies for the housing bonus ordinance incentive that allows it to be reviewed administratively, subject to design review. So no neighborhood meeting is required, but the city mails notices to owners and residents within 300 feet, and the applicant indicated that the property owner did reach out to some of the adjacent property owners to meet about the project. This is a chart of the incentives provided by the housing bonus ordinance. The first is a density bonus. 26 units would be allowed in the zone without the bonus. Unlimited density is allowed with the bonus, but this project only includes 17 units, so they are not utilizing the density bonus. The second is a height bonus. The max height allowed in the zone is 35 feet to the midpoint. The bonus allows for an additional 10 feet of height away from residences, but the applicant's proposal is only 28 feet to the peak, so they are also not utilizing the height incentive. The applicant is utilizing the 20% allowed parking reduction incentive and the administrative review process. In summary, the applicant is in compliance with all procedures outlined in Boise City Code. The appellant also contends that the project does not comply with the CC&Rs for the subdivision that restrict development to single-story commercial uses. CC&Rs are a private agreement that the city cannot enforce, and it would be up to the property owners and the business owners to pursue enforcement of the CC&Rs outside of the city's review process. The appeal application also noted that the project includes various design flaws, listing parking, access, and trash. The planning team and the design review committee found that the project complies with all zoning ordinance and design review standards. The applicant is providing the required parking on site. We did receive ACHD approval of the project. They are requiring right-of-way dedication along Ustick Road for future road widening and closing of an existing curb cut not being used. Based on the ITE trip generation manual, ACHD assessed the development will actually produce fewer vehicle trips than the existing commercial buildings on the site. And the applicant will have to comply with all other department and agency requirements, including those of Boise Public Works Solid Waste, in order to obtain a building permit. In conclusion, the planning team believes that the project complies with all Boise City Code procedures and requirements and the design review standards and guidelines, and recommends denial of the appeal
and approval of the project subject to the original conditions of approval. I can stand for questions, and testimony will begin with the appellant, which is Dwayne Mitchell.
Thank you, Caitlin. Okay, Mr. Mitchell.
Dwayne Mitchell, 12252 Freedom Drive, Boise. This is pretty amazing to me how I've been getting intimidating letters from Mr. Wilmot's attorney friends, threatening me with lawsuits and other such things. And they've got this pretty well cooked. Without any meetings, they say I wasn't approached for any meeting. And I don't know, it's kind of a strange deal. His whole design thing is flawed. He thinks he has drive-through access through my property, which he certainly doesn't have. And there will be a problem over that, I can see. I don't know what else we're gonna do. But I'm really proud of you guys to cook this up like you did. It's pretty amazing. He's got inadequate parking. He's got 17 parking places for 17 apartments, and any fool will know that you're going to have more than 2 cars per apartment. The last meeting here, a lady got up and said that it was really a great thing to have these apartments built out on Ustick because it would block the noise from Ustick. That was kind of an erroneous statement. I don't know who said that, but somebody in your panel did. And you know, it's I have 5 businesses in my building. And these guys had a perfect opportunity to refab that building and turn it back into viable retail and office space. But they didn't do their due diligence when they bought this. And I could have bought it myself had I known anything crazy like this was going to happen. But it looks like you guys have got it cooked up pretty good. So I'll see what my lawyer says now. That's about all I have to say, I guess. Too bad. And there's a beer store on the corner within walking distance. Gun shop next door to it. There's going to be 125, there's a proposed 125 apartment complex across the street with a beer store across the parking lot from that. This place is a disaster in the evenings in the summertime anyway. And this, not only that, there's a residential neighborhood behind it, where they're going to build these 2-story monsters. They're going to look right down these people's backyard. And it's a shame, really a shame. You make trivial work of some guy wanting an easement for a ramp for his wife. I mean, this is a big thing. This is going to change the whole face of this neighborhood. So how do you like that?
Okay. All right. Thank you, Mr. Mitchell. Okay. Go ahead now and we'll hear from the applicant next.
Good evening, Richard Wilmot, Chrysalis Architecture, 3914 East Presidential Drive, Meridian, Idaho. As Caitlin mentioned, we proposed this project under the housing bonus ordinance. I believe we've complied with all of the requirements proposed from staff. We don't have any objections to any of the conditions with any of the staff reports that have been received up to this point, nor do we have any objections to any of the jurisdictional requirements from Irrigation District or ACHD. In terms of just responding directly to Mr. Mitchell's prior comments, I don't even have an attorney. So I don't know what letters he was receiving from me. They certainly weren't coming from me. I'm representing my client. So that may be a situation that he's referring to my client directly, but me personally or professionally have not approached him in that way. In terms of that, you know, there's been some concerns regarding the building restrictions relative to our height. Again, we're proposing a lesser height than what's actually allowed within the zone under the housing bonus ordinance, as well as concerns with the neighborhood meeting. That too was an advantage of utilizing the new housing bonus ordinance, and did not hold a neighborhood meeting, but we've also complied with those requirements. As far as the design flaws, you know, we have, I think, about 3 driveways of various sizes. one for the office building and then 2 more for the drive-through. And with the removal of the drive-through, we are reducing the 3 driveways down to 1. So I think we're providing a little more of a focused access and entry point. And there's currently cross-access agreements between all the properties. So with that, I'm available for any questions, but we agree with staff and the conditions presented to us thus far.
Okay, thank you, Mr. Wilmot. All right, next we'll see we have a representative from the Neighborhood Association, which is the West Bench Neighborhood Association. Any takers? Okay. If I'm gonna have a question for staff here real quick. Crystal, I noticed down here we've got the Winstead Park Neighborhood Association also listed. Or Caitlin, are we looking for a representative from either of those neighborhoods or?
Mr. Chair, I believe they're across the street, but not technically the neighborhood association.
Gotcha. Okay, great. Thanks. Okay. Doesn't look like they're here anyway, so I guess we'll carry on. All right, we'll go ahead and open this up for questions from the commission.
Mr. Chairman,
Commissioner Gillespie.
I have a question for Caitlin to start. So Caitlin, design review normally looks at detailed architectural issues and site layout issues. I assume in this case that is what this meeting or approval was for. Is that correct?
Mr. Chair, Commissioner Gillespie, that is correct. We look for compliance with the code in addition to the design review guidelines.
So, Mr. Chairman. Yep. So Caitlin, so at that meeting, you guys didn't discuss the fact that it had received administrative approval. There, in other words, there wasn't an argument or a hearing about anything other than the architectural layout issues which you just discussed. Is that correct?
Mr. Chair, Commissioner Gillespie, at the administrative level, we reviewed and issued an approval, and then at the design review committee appeal, the appeal points were addressed, which included the design of the building, parking on the site, and the CCNR issue.
All right, thank you very much. Mr. Chairman?
Yeah, please. No.
Mr. Mitchell, may I ask you a question, Mr. Mitchell?
Can you please pop up back to the podium so we can hear you online?
Mr. Mitchell, what is your specific disagreement or objection to the content of that design review hearing? Like what do you think specifically is incorrect?
Well, the whole thing is a flawed project. They've carved out, they've gone into a commercial subdivision and cut a hole in the center of it and surrounded by commercial and putting this development in there. You can't find a development in this town that's done like that. I've been all over. You can't drive. There's no drive-through access. It won't be through my property anyway. I have the building just east of there and with 5 offices in there. And I know where the parking, they think the parking is going to go. They think it's going to go on my property, which I'm going to gate off. And so it's that's a lot of it. But to build 2 stories high, in the CCNRs is the old ones, which I would think had some validity. Since 1958, they haven't been tampered with. You couldn't build anything over 2 stories and no residential in there. And I look around town. I mean, it'd be like going in on 8th and Fort and deciding to put a residential subdivision across from the co-op or something like that, or Vista Village or Collister or a number of places in town. It's a bad spot.
Right. Thank you.
Any other questions?
Mr. Chairman?
Please, Milt. Yeah.
So is it the city's, or I guess it's not, does design review look at whether the proposed development met the parking standards in our code?
Mr. Chair, Commissioner Gillespie, yes, we did do a parking analysis and they are compliant with our code.
Thank you.
Okay. Last call.
Mr.
All right.
Chair.
Commissioner Mooney.
I was looking at the transcript from the deliberations. Commissioner Zuckerman in particular said, I'll just quote it here for the record. I agree with committee member Semple. Everything I've heard tonight is really a P&Z issue and not a design review issue, with the exception of some concern about the height of the building. And we know that this isn't allowed height for this site. I'm very familiar with that area. I would like to think that a two-story building would protect the neighborhood from the noise of U-stick. So, end quote. From that deliberation at the design review, were they pointing it at this body in particular to make any decisions, or were they recognizing that that was their purview?
Mr. Chair, Commissioner Mooney, I believe that we did go through the parking analysis. So I believe that they did consider the parking. We went over the height. So I believe that they did consider the height. I think they felt that it was in compliance with the code.
Okay, thank you.
Mr. Chairman.
Commissioner Gillespie.
So this is a kind of a procedural question, Mary, you might have to chime in. So I'm interested in why the appeal isn't being made of the planning director's original decision of the development, right? Instead, the appeal is being made of a design review committee, which is basically can't look at what I think some of the issues Mr. Mitchell is raising. So can anybody speak to either the possibility of that? And because it's kind of, for me, it's created sort of a mismatch in this hearing.
Mr. Chair, Commissioner Gillespie, we did do the planning director's approval would have been that original administrative zoning certificate approval, which was appealed to the design review committee.
Yeah.
So just to clarify, so the design review committee is the first port of appeal for that fundamental approval. Is that correct?
Correct.
Okay, that's interesting. Got it. So just to be clear, so this commission then can consider all aspects of this case, not just the narrow design review mission.
Mr. Chair, Commissioner Gillespie, that is correct.
Mr. Chairman.
No, please.
So on the record, all I've heard is concerns about parking and compatibility. And
Correct.
the city stated it meets the parking. So maybe if people are anxious to learn more about compatibility and parking, they should ask questions. Or not.
I think everybody's doing their homework.
Mr. Chair.
Yeah.
I think that's the point, is that our packet, as the audience knows, is limited to transcripts from the design review committee testimony, and we don't know what this looks like really unless we go back and so it's not in this particular agenda packet.
Yeah, Mr. Chair, Commissioners, in your packets, there are some drawings and other items that I can also bring up on the screen if there's anything you'd like to look at. We do have the parking information.
And while you're doing that, Caitlin, I guess the question I have is, has there been any more? I assume these drawings are current. The layouts are current.
Mr. Chair, there are some older drawings in your packet as well as the newer drawings. I think I tried to update everything to the most recent in your packets. The drawings do not take into consideration the conditions of approval.
Gotcha. Okay. The original conditions of approval. Okay. I think to that point, Caitlin, the only question I really have on the layout of the site, the driveway into, there's really not much. We're basically doing pavement to pavement. right on the property line. There's nothing that says they need to put a buffer, along that property line.
Mr. Chair, we did not find anything. We did find the cross-access agreement, and we did not find anything that would suggest that the cross-access agreement is not valid. That would probably be a civil matter between the property owners.
Okay. Okay. Do we take another minute or two, team, or go ahead and move on to testimony? Okay. Bill, John, Chris, good. Okay. All right, we'll go ahead and open this up for public testimony. If you'd like to testify on this item and you're in person, please come up to the podium. And if you're online, please go ahead and raise your hand. Okay, well, that was quick. All right, we will go ahead back into rebuttal now, and we will, so both the applicant and the appellant have a few minutes to rebut. There's obviously no public testimony to rebut, but we'll still both give you time for rebuttal. So we'll start with the applicant, Mr. Wilmot. Give you typically 5 minutes for rebuttal.
I'll try to keep it brief. The project utilizing the housing bonus ordinance, it had a few conditions attached to it that we had initially sort of integrated into the project. One of those being the reuse of the existing building. The building is currently connected across two properties. And we felt that there was value in utilizing the existing structure, both from an ecological perspective, and then also just how it was how it could benefit us and the type of buildings that we were proposing on the property. We did take down one building that was an existing drive-through, and are building basically a new structure in that particular location. Unfortunately, the square footage of the building reuse was more than what was allowed by the HBO. So it wasn't actually a beneficial condition that we could use for the project, but that was our initial intent. And Caitlin and I had many discussions about how, how we could try to continue to use that as a benefit. But again, our square footage was just offset was too much. And then in terms of the CC&Rs that Mr. Mitchell was referencing, and the multiple stories, the Buckhorn Gun and Pawn that is on the corner at Ustick that's adjacent to our property, it actually has a second story in it currently. So I don't really know how that would have been allowed at any given point if this was a concern at the time that permit was issued for that structure. But we're trying to be sympathetic to what the housing bonus ordinance means, what its intent is, and I think we tried to hit on multiple marks, and I think we're doing that currently. So with that, I'll stand for any questions.
No questions now. Thanks. Okay. And then now, Mr. Mitchell, you get an opportunity to rebut.
Yes, in reference to the gun shop, that's an old gas station, and that's why it's two-story. They had bays in there. That's why that's the way it is. But I'd like to go back to the parking and fire access. I don't know how they're going to get a fire truck in and out of there. And you've 17 parking places for 17 apartments, with maybe a couple of handicapped, and they're going to probably have no less than 2 cars per apartment. And where are they going to park those cars? That's just one thing. And then, like I say, there's no place for anybody no common area, I guess you could say. Mr. Wilmot said there is a park a couple of blocks away. That's true, but there's nothing right around there. it's a problem with children wandering all through there anyway. And we blocked access just to keep cars from constantly driving through there. And the access will stay blocked. And if I have to put a gate up, I'll give access to the fire department, but that'll be that. I'm gonna have to do that. But I don't know. It's I don't know what else to say about it. It's going to be a mess. It's going to create a real mess right there. Like I say, it's right in the center of a commercial development. Look around town. There's nothing like it. Just be one of a kind. You set a new precedent. You can build them everywhere.
Okay.
Thanks for your time.
Thank you. Okay. All right, we'll go ahead and bring this back before the commission to render a decision. Again, this is CZC 21-00291.
Mr. Chairman,
Commissioner Danley.
I make a motion that we move to deny the appeal and uphold the approval of CZC 21-00291, subject to the original conditions of approval.
You have a second?
Second.
Commissioner Blanchard with a second. Commissioner Danley, would you like to start us off with some discussion?
Sure. Thank you, Mr. Chair. Mr. Mitchell, I'm sure you're the first of what's probably going to be several folks over the next, who knows how much time, to come in and appeal a decision like this, because this is new and this is a new process for the city of Boise. And I'm sorry it wasn't something that necessarily allowed you to participate as much as you'd want. I understand that. I get the frustration there. However, the city of Boise, as well as other government entities, often get sort of pushed in a corner and told that we move at the rate of plate tectonics when it comes to policy changes. And in this case, that's exactly what this policy is intended to do, is to streamline development processes, which is something that we are called on all the time to do, to help move the bar a little forward and reduce some costs because of the housing crisis that we all know that we have. In this particular application, we also know that we are, getting units that are below market rate, AMI, right? 70,000 or so a household right now in our city of Boise. That means that someone can get into this unit for maybe 50, 55. That's still $25 to $30 an hour. Unfortunately, the testimony is over, sir. So respectfully. So my point is that this process, again, is new. It was called upon over and over for the city to enact. We've listened, we've done, and this is the byproduct of it, unfortunately. Maybe there's future tweaks to be made. Maybe it's not perfect. But it's where we are. And I think that the project that as is proposed is a good one. So one more thing I was going to say is that in the last year, for example, on the commercial retail front, I think that we've had maybe one, maybe two applications in the entire time that have been commercial and or retail applications. We have had so much residential. We're not seeing that energy like we once did. My point is that things in the way that we consume is changing, right? And our market is changing. And right now it's the housing piece that has a tremendous amount of energy. And is, again, what our ordinance here is permitting to try to do and try to work toward and make a dent in this thing that we all know that we're working with. So that's a lot to be said. I apologize for being a little long-winded, but I think that we're on the right track. Maybe there's some tweaks to be made, but I support the application and thus the denial of the appeal.
Thanks, Commissioner Danley. Commissioner Blanchard, do you want to have anything to add?
I don't really, just that when something like this comes before us, we need a lot more than some undefined, you guys cooked up something that we didn't. I'm just confused about who those guys are and what the cooking up thing was. So I don't even know what we're supposed to be considering here.
Can I speak to that?
No, I'm sorry, sir. The testimony is closed. Any other discussion?
Mr. Chair,
Commissioner Moore.
I think in terms of, I know I'm in support of the motion, and in terms of compatibility, I think I am supporting the motion because I do think it is compatible from our aerial map, I'm seeing an area that's pretty heavily residential. So I feel like more residential is compatible. It's 2 stories, even if most residential is 1 story, that's only a 1-story difference. It's not terribly significant. I think it's still within the height restriction of the zone, even with that, without the housing bonus ordinance incentive. They're not even utilizing that. So I think, there's no increases requested there. They're removing an existing drive-through in a residential neighborhood. I think that's beneficial in terms of emissions. Adding landscaping, reducing urban heat island effects. And I think in terms of fire access, I have a letter in my packet from the fire marshal indicating their approval with conditions, but approval. So I'm pretty confident that it's compatible and that, fire and everybody has looked at it and vetted it and I think integrated into that site.
Thank you, Commissioner Moore. Okay. All right. We can go ahead and move this along to the vote. Again, this is item 3, CZC 21-0291. We have a motion to deny by motion to deny the appeal by Commissioner Danley with a second by Commissioner Blanchard. Will the clerk please call the roll?
Schaefer,
Aye.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Ganley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay, thank you. All right, up next is item number 6, CUP 22-6 and CVA 22-12. Myra's Spanish Preschool and Daycare LLC at 1505 South Empire Way. This is a conditional use permit to change an existing residential group childcare facility to a large childcare facility on 0.27 acres in R1C zone. And we're here from staff first, Delaney Garlick.
Thank you. Good evening, Mr. Chair, members of the commission. Before you is a request for a conditional use permit and variance. The applicant is requesting a conditional use permit to expand an existing in-home group childcare center to a large commercial childcare center to serve 25 children on 0.27 acres located at 1505 South Empire Way in our R1C zone. The site abuts a C2D zone directly south. Less than 300 feet to the west is a elementary school, and located just north is the site is located just north of a neighborhood activity center at Overland and Empire Road. This neighborhood activity center promotes providing local services to the surrounding neighborhoods. The existing building operates a residential childcare home serving 12 children. The proposal would convert the single-family home into a commercial childcare center with the operator living off-site. The proposal meets all the conditional use permit criteria for a large childcare center. The proposed on-site parking is located at the rear of the property with access from South Empire Way. The applicant is requesting a variance to the proposed parking, which is within the rear and street side setbacks. The exceptional circumstance is that the existing orientation of the building prohibits any expansion to the required parking. Other areas on site were considered for the required parking, but would not be viable due to the requirements to maintain both the indoor and outdoor space ratios for the number of children being served. The site lacks alley or cross access from the property to the south, and ultimately the planning staff found that this to be the only viable location for the proposed parking, which does not cause an undue burden on the surrounding neighborhood. Public comments were received, which expressed concerns with traffic, noise, compatibility with the residential neighborhood, and impacts to neighbors' mental health. Staff found that the project is compatible with the comprehensive plan and meets the required findings. A letter of support was also provided by the neighboring parcel to the south. Staff recommends approval with conditions, and a final action is needed tonight, and I'm available for any questions.
Thanks, Delaney. Okay, next we'll hear from the applicant. Yeah, please. Yeah, please come on up. Yeah, please come up to the podium. Mhm.
Do you want to translate that?
Yeah, I think that'd be okay. Yeah, I think that'd be fine. So, yeah, we just need names. We just need names and address for the record. And typically we do about 10 minutes for this. But you don't have to use that much time, of course.
Mi nombre es Mayra Ramírez y soy la dueña del 1505 South Empire Way.
She is Mayra Ramirez. She is the owner of the Spanish preschool and daycare, and she is located at 1505 South Empire Way.
Okay, great. Thanks.
Estoy interesada en incrementar mi daycare porque es una necesidad que tienen las familias para el cuidado de los niños y es algo que me apasiona educar a los niños.
She is very moving forward and expand the daycare and preschool because there's a highly demand in the area, and she is considering to a potential to help the neighborhood and all the people around to provide the daycare for the kids, and people can go to work and improve the life of the Boise City people.
Ya,
¿Qué más quiere agregar?
ya que los niños son muy dulces, no hacen mucho ruido, nada más salen un poco en las mañanas y en la tarde y es algo, no sé, que no hace daño mental a las personas.
She's addressing some of the concern of the neighbors about the noise and their mental health of the neighbors around the 1505 South Empire Way. But she said that we have an elementary school within a block of the property. Also, the Overland Road is a really busy street already. And she said there is no reason the noises already existing. And from the kids coming out of the school, the buses driving around, there is a noise in the area anyway already.
Thank you.
Okay. All right. Thank
Thank you very much.
Thank you. Okay. Next, we'll see if we have an representative from the Neighborhood Association. Is there anyone here from the Bora Neighborhood Association? Okay. All right, we'll go ahead and bring this back to the commission for any questions of staff or the applicant.
Mr. Chairman.
Commissioner Gillespie.
Delaney, can you pull up the site map or and how it's situated around with the other properties around it? So like a bigger view. Thank you. So could you just address the city's opinion on just basic compatibility and adverse impact on the surrounding residential properties in particular, since I assume that's where most of the concern is?
Yeah, Mr. Chair, members of the commission, in terms of the compatibility, first and foremost, the existing use is a childcare facility. So we are looking at an expansion of an existing use. The site abuts directly to a C2D zone and just half a block from the Overland and Empire intersection there. So we are looking at kind of the surrounding area. We have a neighborhood activity center located half a block south of the site. We also have the elementary school less than 300 feet to the west. So in terms of compatibility, this use does fit well within both the residential aspect of the neighborhood and with the commercial being directly south along Overland, we felt it was a appropriate expansion.
Please, Milt.
Delaney, could you pull up now and just discuss, because we can kind of see it on the left side of this, but just show us the buffering and the space between this property and particularly the house immediately to the west, which is, I think, the one most affected.
Yeah, Mr. Chairman, members of the commission, the site plan might help display kind of the buffering here. We have the existing structure at sort of an angle on the corner of Empire Way. Most of the play structure and play area is directed towards South Empire Way at the rear of the site. They do provide the ADA parking in the front with the front entry off of Marvin. So with the proposed parking in the rear, they are directing all traffic sort of away from those neighbors and along that South Empire Way.
Mr. Chair,
Commissioner Mooney.
question for Delaney again, regarding the variance for the proposed parking. 6 is required, or 3 is required, 6 is requested. Is that how I understand it?
Mr. Chairman, Commissioner Mooney, that is correct.
So they could do 3 parking looking at this site option just above the ADA parking and would be in compliance without a variance. Is that correct?
Mr. Chair, members of the commission, that the different kind of orientation of the lot, if they were to go north of the ADA parking, they would be in the front setback as well on the Marvin Street side. So there would still be a variance request at that scenario.
Okay. Mr. Chair,
please.
Crazy question. How do you condition one bicycle parking spot?
Mr. Chair, Commissioner Mooney, that one bicycle space is a requirement with the child care facility. So once we go into that commercial realm, there is a requirement in code to provide one bicycle space.
So it'll be a secure in the ground. You can lock your bike.
Yeah,
to
a
it.
bike rack. Yeah.
Okay, thank you.
Mr. Chair, Commissioner Blanchard.
Delaney, this is planning 101. I'm sorry, but so if we grant the variance, what does that mean for the future use of the property? So Myra decides to retire in 20 years and we've given a variance for a parking lot. What does that mean for the future use of the property?
Yeah. Mr. Chair, members of the commission, the CUP and variance would run with the land until a future, entitlement or request came in. It would allow for future parking to remain in that rear street side setback. So yeah, if the use were to change, that parking could remain or be proposed in a different orientation at a later date.
Mr. Chair, but only parking. I couldn't tear the park. I couldn't buy the house and tear the parking out and put a garden in there like it is now.
Mr. Chair, members of the commission, if you were to change the use, yeah, you could change that parking. Once you did away with that parking, that variance is now void.
Thank you.
Mr. Chair.
Commissioner Moore.
And Delaney, is there any landscaping required for an increase in the size of the child care center? Would that trigger an additional landscaping requirement?
Mr. Chair, members of the commission, the site has existing landscaping. This site plan might not show all of the existing sort of trees and irrigated lawn area that's dedicated to the outdoor play. I don't believe that there would be additional landscape on top of what's already existing.
Delaney, if I remember correctly from the packet, the facility is big enough to accommodate without much change, right? The number of children that's proposed for the property.
Mr. Chairman, the request does meet the space ratio requirements for both indoor and outdoor. There will be tenant improvements required to upgrade this building from a residential occupancy to a commercial occupancy. So there is some tenant improvement, but the footprint and the proposed site layout meet all the large childcare criteria.
Thank you.
Mr. Chair.
Commissioner Mooney.
There was a previous 2020 submittal for a CUP that was rescinded. Can you answer the historical background on that? What transpired there?
Yeah, Mr. Chair, members of the commission, I think initially the applicant attempted this very similar request to expand. I believe they needed more time to kind of figure out how to upgrade the structure to meet the commercial code requirements, since is a significant change in our building code to go from a residential childcare to a commercial childcare. So they did come back and resubmit when they were ready to move forward with that.
Okay, any other questions? All right, very good. Thanks. We'll go ahead and open this up for public testimony. If you'd like to testify on this item, please come on up to the podium. Or if you're online, please go ahead and raise your hand.
Thank you, Mr. Chairman, member of the commission. My name is Ramat Walizada, and my father, Izzatullah Walizada, owns the 1506 South Empire Way, right across from Mr. Fuentes' family. That is, we've been there for over 30 years, and it's a very quiet, peaceful neighborhood. And I pretty much grew up over there and spent all my life, and my kids also grew up over there. So, but coming outside before these guys moved in, you couldn't even tell that there's people live in this neighborhood because it was so quiet. And we have, in the neighborhood, we have a lot of elderly people that live there, you know, that 30, 40 years, and they're still over there. And so back in 2020, Mr. Ramirez, the husband, and Maria invited us to their backyard and told us about their plan that they're going to go ahead and change their house to a full-fledged daycare or slash preschool, and ask us our opinion, what we think. I said they had an interpreter in that time as well, so I was just talking to them, and also I told them that right now you guys have 10 children, taking care of the 10 children as a daycare, and we cannot handle the noise. And I cannot see that 25 or 30 children that they're going to have as a full-fledged preschool. So after talking for 10, 15 minutes, the husband said that you're right. We're going to go ahead and find a place other than here to make a daycare and preschool. And so we just talked about it, and so he was considering, you know, finding a place in Nampa, Caldwell area. And so, and we left it that way for them to find a place until today. They changed their mind again and resubmit the application, you know. And so Empire Way has been peaceful since the day we moved in, you know, with our family 30 years ago. And it's been, we try to keep it like that, you know. And like they say that there's a school about a couple blocks or a block and a half away to that side, but that's not going to affect as much as these guys, 10 kids that they have. I mean, for most of us that they have like children, you know, they can see the 2, 3 of them when they get together, they make a big noise. And so for people that work graveyard night shift, they come in to stay, you know, sleep at home right across from their house. It's impossible. The noise is crazy, and then they get like music going on, you know, for birthday celebration and all this stuff, you know, that they have loud music playing all the time. So those kind of stuff is to consider for approving this conditional thing. So thank you. I don't have anything else to say.
Okay, thank you.
Good afternoon. My name is Amner Bu. I am Mayra Fuentes' husband. The only I want to add there is the folks I speak here. This is my second time I met here. The first time he being in our home, and today. We bought the house in 2017, and this is my second time I saw him. And his dad, I met him, and they don't live in the house. They own the property, but they don't live in the house. And I'm surprised when he says it's noisy for him when he don't live there. He have a different house, and he live in different place. The noise has been there. If you see behind our house is a building commercial. They have a shop close to his house. They're doing mechanic stuff. They heat hammer. They use compressor, and there's a noise. There's no exist in that time. And my point is, when you come in here and complain on something, it's because you live there. But he no live there, and his dad no live there. They live in a different place. Thank you.
Okay, we have someone online. You're gonna, since you're the applicant, you'll have to sit tight. You'll have a few minutes to rebut testimony here. 1 minute. Okay, we'll go ahead and go to, we have a hand up online.
Can you hear us?
Nah, if you can turn it up a little bit, it'd be helpful.
Sorry, I can remove. Is it now? Can you hear me now?
Yeah, it's pretty good. Yeah.
Okay,
We'll
cool.
go with it.
My name is Alexander. I'm just interpreter for Tamara, who is Kareem's wife. So she will speak and I will interpret.
Okay, could you give us an address, please, for the
Yes,
record?
address. 1512 South Empire Way, which is that house directly south of the property, of the proposed parking lot. I assume. Oh no, wait, west, direct east of proposed parking. Sorry. That's it.
Okay, thank you. Go ahead, please.
Okay, пожалуйста.
Hello. Меня зовут Тамара.
My name is Tamara Sinkevich.
Вот. Я являюсь соседкой.
I am the neighbor of the proposed facility.
Да. И самая пострадавшая сторона это моя, потому что я живу напротив детской площадки.
And I am the most affected person because I live right across from the playground.
По состоянию здоровья я нахожусь дома круглосуточно.
Because of my mental health, I am at home all the time.
Вот. И наши соседи обязаны выгуливать детей на детской площадке, и я целыми днями только,
Our neighbors, kids of the facility play on the playground, and all the day.
Наблюдаю только за детьми, как они включают колонки, включают микрофоны, громко шумят. Дети неорганизованные, недисциплинированные.
And they use the speakers and the microphone, which amplify the sound. And the kids, of course, being noisy as it is, with only 10 kids, and also obviously being little kids not being super ruly.
Я понимаю, что детей надо развлекать, потому что они маленькие, ими надо заниматься.
I understand that the kids are small and they need to be entertained and they need to walk outside.
Даже дома, сидя на диване, я вижу, как дети ползают по горке и очень громко шумят.
But even at home, sitting in my living room on the couch, I can see kids running down the slide and being really loud.
И на сегодняшний день, как они гарантировали, что у них 10 детей, если это число увеличится, шума будет в 2 раза больше.
And now they only have 10 kids. When they will have 25 kids, it will be twice as much noise.
Да, и еще я хотела сказать, что
And also I want to talk about
на сегодняшний день привозят 10 детей, 10 раз хлопнули дверями машины, припарковались, отвели детей, сели в машину, опять хлопнули. А потом это 20.
10 kids, 10 times they park the car, they slam the door, they take the kids inside, come back, open the car, slam the door, leave. That's 10 kids. When it will be 20 kids, it will be 20 times as much every morning and every evening.
И как сегодня я поняла, они парковку сделают опять под моим окном, только вторая часть киндергарден будет, а вторая часть будет паркинг. И весь основной шум это мой.
And then so as you can see, the playground will be in front of one of my windows. The parking lot will be in front of the other window. So basically all the noise from the parking lot and from the playground will go right into my window. Еще что-нибудь?
То есть на сегодняшний день они уже меня беспокоят, а если это увеличится.
That's your time. Thank you very much.
Yeah, just really quickly, one more thing. It's already bothersome now, and if it will noise increase, it will be even twice as much or 3 times more bothersome. Thank you.
Okay, thank you.
Хорошо, все, успели. Нормально. Все нормально. Все хорошо, вы все сказали. Больше вы не успели за 3 минуты сказать.
Спасибо, вы так быстро еще перебили.
All right.
Хорошо. Может что-то делать.
So, Mr. Chairman,
Commissioner Gillespie.
just a quick question to you. So the gentleman who might like to testify acted just as an interpreter. So
Well,
under one interpretation, he didn't really give his own testimony.
Sure.
I'm sort of wondering if we shouldn't just allow his 3 minutes of fame. And
yeah, that's
because
fair.
he
No,
was
that's fair. That's
translating-
a good point. That's a totally fair point. Yeah, please come on up.
That's spirit Basha.
You're right. Sit tight for 1 second. We still got a little technical. We're good? Okay, go ahead.
All right. Thank you, Mr. Chairman.
Yeah.
The first time I appeared here, I was doing the English translator at the best of my ability.
Yeah, absolutely. Absolutely.
Okay.
Appreciate that.
My
Please.
name is Vladi Bumercado. I live on McMullen Street, which is really nearby. And as we can see, the footprint of the area is already a commercial area. Behind where the parking lot is, as you can see, is a little shopping mall. To the right is a shop, been there since I've been in Boise since the 1990s, over 30 years. The noise already exists there. You can hear people trying to take tires out, mounting engines right behind the person who spoke before here, that they own the property, but they rent it, they don't live there. So I don't know what the point is to argue about the noise. Sooner or later, this area, as the city of Boise is growing, it will be there something, whether it's a daycare, school, another business, so there is gonna be noise. This property is essentially located, and I can see, and I support the idea to increase the child care from 12 to 25 basic, and the need of our city, and the need of our citizens to accommodate their kids in a safe place where they go to the daily activities, which is work, travel, work for the city, or do whatever the people needs. We've probably all been there. The parking lot is gonna look very good for the childcare. It's gonna provide actually less traffic in front of the property. The ADA parking is gonna be probably the only one. It's gonna be between the Empire Way and the streets goes through the Grace Jordan School. The parking lot will bring this nice childcare facility to make it easy on everybody approaching the daycare on a daily basis. And most of the noise of the traffic will be before 7 and probably around 6 o'clock. So the traffic is not gonna interact with the school, with the neighbors going to work or coming in. Thank you very much. That's all I can add.
Okay. Thank you. Any other?
Mr. Chair, we have someone online as well.
Oh, okay. Thanks, staff. We'll try and do in person first. Got ahead of myself. I apologize.
Good evening, everyone. My name is Catalina Boo. The address is 7837 West McMullen, in the same neighborhood. I can speak to that neighborhood. I attended Bora High School. I know that area like the back of my hand. This increase with conditional use permit will not only benefit the community, but also offer the students that go to Grace Jordan and their families another option that's close by. So the other daycares that are close by are closer to Whitney Elementary School down the road, another bilingual school. This supports families that are looking to offer their children with greater access to opportunities speaking Spanish. As a product of someone who lives in a bilingual home, many opportunities have come my way because of bilingual. I know that's more of a not completely in with the permit, but also will elevate our community in the future. So allowing for this childcare facility because the children are children, they do make noise, they do go down the slide, but the owner of this preschool and daycare has taken great lengths to increase the property to be up to code and to meet all of those, to make those necessary changes in order to support the daycare in a way that's going to maximize what those students can use, and so that the neighbors are going to be able to not hear as much, because on the inside they have created classroom space and updated their kitchen to an area where the students can eat. So they're not spending all of their time outside. They do play outside. We know that about children. And then of course, again, with the parking, it will allow for the traffic to be more towards Overland, where a lot of the traffic is, so that those cars aren't even going to Marvin or past that area. They're going to be parking behind the building, and their children will probably access the building through the backyard or going around front. I think this also solves a problem that's currently happening where they park on the street. I think it would be great to have a parking lot behind so that they can park behind, maximizing more space that is on Empire right now. And that's all. Thank you.
Okay, thank you. Okay, anybody else in person? We have a few folks online, so. Okay, we'll go ahead and move back to the online folks. Staff, do we want to start with?
I've unmuted Patrick Spouts.
Okay, we'll go with Patrick Spouts. Can you hear us?
Thank you. Yes, my name is Patrick Spouts. I live at 753 West Sandstone, Boise, Idaho, and I want to speak briefly in support of the plan and proposed variance, and specifically want to say that I really appreciate daycares that are integrated with residential neighborhoods. My kids go to Boise Bears on 8th and Eastman in the North End, and it is lovely being a place that's walkable and having access close to people's houses. So I think it's a really compatible use with residential neighborhoods writ large. I'd be sad if I had to drive my kids to down busy roads and then have them play outside on a major arterial. So in general, I just kind of want to speak up for the project and the compatibility of these kinds of options for people to have high quality daycare in their neighborhoods. Thank you.
Okay, thank you. And are we back to Karim Nassim staff? They wanted to speak again or no? No? Oh, okay. All right, well, we'll go ahead and close public testimony on this item and go ahead and bring it back before the commission to render a decision. Oh, sorry, rebuttal.
Should do rebuttal.
Dan, I'm sorry.
Almost.
You're keeping me honest over there, Milt. I appreciate that. The applicant now has 5 minutes to rebut the public testimony. So if you want to come back on up to the podium, if you want to make any of their final statements or rebut any of the testimony. Okay, let the record show the applicant's yielding their time for rebuttal. And now I think we can bring this back before the commission to render a decision. Again, we're CUP 22-6 and CVA 22-12.
Mr. Chair.
Commissioner Blanchard.
I move that we approve CUP 22-06 and CVA 22-12 with all the terms and conditions outlined in the staff report.
Second.
Got a motion to approve from Commissioner Blanchard and a second from Commissioner Gillespie. Commissioner Blanchard, you want to start us off with some discussion?
Sure. Thank you, Mr. Chair. You know, the noise complaint seemed to be the biggest one here. And again, I live in that neighborhood as well. And it's noisy. Overland is noisy, and you know, commercial stuff is noisy. The business has been operating there for I don't know how long. So I don't have a concern with any of that. One thing that I did hear neighbors talk about was the amplified sound. So I don't know what's going on with microphones and speakers and singing and that kind of thing, but that's dealt with in code, and certainly neighbors are free to make a code enforcement complaint if there's amplified sounds that they're concerned with. My primary concern with granting the variance was what happens with the future use of the property, and that's Commissioner Gillespie is always a real stickler on this one, and I appreciate him for that at times. And this is a time where I feel pretty confident that if the use changes in the future and it goes back to a residential use, that parking lot can revert. So what I wanted to avoid was Myra and her family retiring, and then they want to sell the house, and then somebody buys the house and it's like, oh good, we're stuck with six parking parking spaces here that we don't want. So that was my big concern, and Delaney has assured us, I think that's is not going to be a problem. So there's several other daycares in that neighborhood. I drive by all three of these, yours every day, and two others on Curtis Road every day, as I set out to do my thing. And so I also think it's a great thing to have childcare integrated with neighborhoods. So I wish you guys luck with all of this, and that's why I'll be supporting this.
Mr. Chairman. Thank you, Commissioner Blanchard. Commissioner Gillespie.
So I agree with Chris, and I do also agree that the compatibility issue, basically, as I understand it, came down to noise. And so I was considering two additional conditions. I'd like folks' view on it. One is that we add a specific condition requiring the applicant to maintain a 6-foot fence around the western property line as well as the southern property line. Now, I think from the photo, we didn't talk about this in Q&A, so I kind of wish we had, but I think from the photos, is an existing fence there now. And it's kind of like a daycare has to have a fence, right? So I'm not sure about putting it in as a condition, but if it's going to be a daycare, it's really that person just to the west that is most affected by the noise. So I wouldn't mind a condition saying that they have to maintain a 6-foot fence along the western and southern property lines. I'd be interested in the city's view on that. The second question is this amplified music. So my recollection of the noise ordinance is that really it's sort of a 10 p.m. to 8 a.m. no amplified sound can be heard off the property. I think that's it. So I was wondering if we wanted, we could, and we've done this in the past, is say no amplified sound from except between 10 a.m. and say 5 p.m. So people who want to sleep in, right, 10 a.m. or 9 a.m. you're so they're not starting the karaoke at 8 in the morning. And then, it stops at 4 or 5. I would certainly entertain that. But again, because we didn't ask that in Q&A or get into that, like, why do they need amplified sound? I was a little hesitant to propose that. Those are definitely two tools, the fence and the amplified sound, that we could think about to make it fit better in this space. Otherwise, I'll support.
Okay.
Mr. Chair.
Thanks, Bill. Commissioner Moore.
And I actually did coincidentally have the noise ordinance up in my computer because of the sound amplification, just like everybody else. And the way I'm reading it, I don't see a timing aspect to it. I think it's just, it shall be unlawful for any person to operate or permit the operation of any loud amplification device in such a manner that the sound therefrom is plainly audible within a place of residence, not the source of the sound, or plainly audible upon a public right-of-way or street at a distance of 100 feet or more from the source of such sound. And I think that, as I interpret it, and there's a bunch of exceptions which mainly seem to have to do with holidays and emergency vehicles. I think that right there kind of covers much of the sound issues in terms of amplification. Now, kids playing and things like that, I think, is a little bit different situation. But just amplified sound itself, I think I'm comfortable with that, with noise ordinance covering us for that.
Mr. Chairman.
Commissioner Danley.
I'm in support of the motion, and with respect to Commissioner Gillespie's potential additional conditions, certainly the fence to me makes sense. I think we can get there on the amplification one way or the other. I was in that same headspace, but going at it a little bit differently. Because this is a CUP, we have, the additional obligation to make sure the mitigation is correct, as we've gone through that a lot lately, haven't we? In this instance, what I think we might have, and I'd also be interested to hear what other commissioners say on this, and that is that we can maybe take advantage of the fact that it's required to have 3 parking stalls. They're asking for 6. What I'm wondering is if the parking stall that is immediately to the farthest to the east, I think it is, which is nearest to the homes on the other side that are most upset about noise, is instead of being a parking stall, is maybe it's big planted tree that helps to buffer and mitigate some of that sound. We are a city that has a program that straight up gives trees away and would probably do so in this, and they would absolutely qualify. So I'm just thinking that might be a way to sort of try to help thread the needle. They still get 5 spots, which is still 2 more than what is required. It gets us to the nature of the CUP. It helps with sound absorption and all of the things that we're hearing. So that's just an idea that I had worth maybe something or not.
Okay, thanks, Commissioner Danley. Okay. Yeah, I think that idea has validity for sure, Chris. I mean, if you look at any commercial parking lot, it's required to have trees planted in it. So I think that's a fair concession in my mind.
Mr. Chair.
Commissioner Mooney.
I'm also in support of the motion, and I agree with Chris's thoughts about the lot.
Very good. All right. So I think I already needed a break. I don't know if you guys could tell that, but now you put me in a position where I got to work through amendments. So I appreciate all that too. So we have a motion to approve and a second. The motioner was Commissioner Blanchard. Commissioner Gillespie proposed some amendments.
Well, I'm sensing that since no one has made a motion on the amendments, I think maybe we should just vote straight up on the original motion. Unless someone, now's your chance. I actually don't feel that strongly enough to make them. I would approve the motion as is.
Okay.
We'll vote for it.
Okay.
Mr. Chair.
Commissioner Danley.
I will therefore then make a motion to amend the original motion for an additional condition as part of the approvals for CUP 22-6 and CVA 22-12 to read the easternmost parking stall nearest Empire be replaced with, instead of a parking stall, a hopefully large canopy tree as part of mitigation for, in particular, sound.
Okay.
Second.
Yep. I think that works. We have a motion and we have a second. The motion was Commissioner Danley and the second was Commissioner Mooney. So we'll go ahead and vote on the amendment. Yeah.
Yes, that is correct, Mr. Chair. This vote will be whether or not to amend the motion, not whether or not to approve the amended motion.
Right, correct. Thank you for the clarification. Okay. Got that? Yes. All right. Will the clerk please call the roll?
Schaefer,
Aye.
Squires,
Aye.
Blanchard,
Aye.
Moore. Aye.
Gillespie,
Aye.
Danley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay, great. Thank you very much. I don't think there's any more discussion, right? We're good. Go ahead and move to the main motion then. This is a motion to approve CUP 22-6 and CVA 22-12 with the approved amendment from Commissioner Danley. The original motion was from Commissioner Blanchard with a second by Commissioner Gillespie. Will the clerk please call the roll?
Schaefer,
Aye.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Stanley,
Aye.
Rooney,
Aye.
all in favor, motion carries.
Okay, great. Thanks, everybody. We'll go ahead and take a 5-minute break. 8:35. Okay, all right, let's get this, let's get this rolling. Okay, up next was originally item number 7. It's now number 8 tonight, but that's immaterial. PUD 22-21 Rodney Evans and Partners. Project address is 2408 South Broadway Avenue. Conditional use permit for a planned residential development comprised of 35 multifamily units on 0.85 acres in a C1 DDA zone. We're going to hear from staff first, Mr. David Mosier.
Thank you, Mr. Chair, members of the commission. The applicant is requesting a conditional use permit for a planned residential development comprised of 35 multifamily units located at 2408 South Broadway Avenue on approximately 0.85 acres in the C1 DDA zone. And as you can see from the aerial photograph, the property is located along the east side of Broadway. The area is primarily made up of detached single-family homes to the east with a mix of both commercial and residential uses along Broadway Avenue. The site is also located approximately a quarter mile from Ivywild Park to the east. As you can see from the site plan, the development consists of 2 3-story multifamily buildings containing a mix of 1 and 2 bedroom units. The project proposes 35 dwelling units with a density of approximately 41 units an acre, and the C1 zone supports 43.5 units an acre. It will comply with the setbacks, building height, and provides all the required parking. In addition, it provides 2 amenities, which include covered seating with a fire pit and open areas located within the patios and balconies. The property is also located, as mentioned before, about a quarter mile from Ivywild Park. In summary, it complies with all the required findings as per the development code. In addition, I'll note that the existing DA associated with the site does not prohibit the use, and the project complies with all its requirements as well. However, the applicant has expressed concerns with the recommended condition of approval, which requires an 8-foot wide landscape buffer and 5-foot wide detached sidewalk be installed along Broadway Avenue. The applicant would like to maintain the existing attached sidewalk along Broadway and then widen it to 7 feet. This is similar to the existing improvements along Broadway to the north and south. This diagram shows the landscape buffer and the detached sidewalk's approximate location given the proposed site plan. The sidewalk could be located next to the building about 4 feet or so from the building, and the proposed landscaping will be moved to the landscape buffer along the street. This landscape buffer should contain as a minimum a class 2 tree planted every 40 feet. The planning team also received public testimony from neighbors concerning the project in terms of loss of the existing house, compatibility, parking, building design. In summary, the planning team addresses these concerns within the project report and believes that the project will address all of these public concerns. In conclusion, the planning team recommends approval of the PUD. Thank you.
Okay, thanks, David. Next, we'll hear from the applicant.
John King, 306 North Mobley. Mr. Chair, members of the commission. I just want to do a quick overview. I know it's getting late, so we'll move through it quickly, and we'll just kind of jump on the one site-specific condition that we'd like to discuss. As David noted, here's the site, 2408 South Broadway. It's 0.852 acres. In this area, we're allowed 43.5 units per acre, and we are proposing, well, we could accommodate 37. We are proposing 35. He mentioned the setbacks, height, parking, all in compliance. Just wanted to go over just a couple views of the project, some renderings. This is sort of from the inside looking out towards Broadway. Wanted to have one building face Broadway. We have a plaza area between the 2 buildings. Entry from within inside the project, looking at one of the main entries. Again, the plaza on the back left between the 2 buildings. And then this is the view from Broadway. We want the building to address the street. We do have some units on the ground floor. And then on the left side, there are some existing trees, which we would like to keep. And if we need to detach the sidewalk, those would need to be removed. Here's an image of just one of the site amenities, sort of a covered amenity, central to the project for gathering space. They'll also provide some covered bike parking. It opens onto a barbecue, and to the item I wanted to discuss. So site-specific condition number 4 is an 8-foot landscape buffer and 5-foot wide detached sidewalk along Broadway. So in looking at Broadway, I have some a little graph in the center. It's kind of hard to see, but that's about 2.1 miles from South Broadway up to Myrtle. And there's been some fairly new developments there. And there's really only one spot, and it's right, it was the Popeyes in that upper right corner. And I think it's, I can't think of the sandwich shop there, but that's the only place where there is any detached sidewalk in 2.1 miles. So times that by 2, that's 4.2 miles, and we have about 149 feet. It's just not desirable for us to detach it at that one location. Also, just north of us is Federal Credit Union, a fairly new building. It is not detached either. We could accommodate it on site. It just would really prohibit the residents at the ground floor there. We are proposing to increase the sidewalk to 7 feet. And I think in Blueprint Boise, Chapter 3, the corridor section, it speaks to detached, you can either detach the sidewalk or widen the sidewalk. So we would certainly like to just widen it. We'd like to just give a little bit of privacy there for the residents, landscape it, kind of soften it slightly, and then keep that landscaping again on the left side of the image so that we could keep, there's 2 sort of substantial trees. We also feel it helps screen the parking. We do have some compact parking that faces Broadway. We really would not be able to get any type of vertical planning or any type of softening or any screening kind of in front of those cars. And I think the rendering sort of illustrates what we'd like to do there. A couple of concerns also we heard at the neighborhood meeting was privacy, especially the houses to the east. So what we have done there is this is sort of a view. There's a 6-foot existing fence. We are proposing trees. And then these windows are quite small. They look out of a bathroom and a bedroom. So we really didn't want something to be peering down into the backyards. And again, we're meeting the setbacks and meeting the height requirement. And that is all for me. Thank you.
Okay, thanks, John. Next, we'll hear from the Neighborhood Association. I think Mr. Berg is with us online. Yep.
Thank you. I'm in my own capacity. I'm not actually representing CENA tonight. CENA didn't take a position on this project.
Oh, okay. Okay.
I'm happy to go now if you want, but I just wanted to make.
Eric, hold up. Eric, hold up, please. Since you're not representing the neighborhood association, we'll go ahead and hold on your testimony until we get to the public portion of the hearing.
Sounds good.
Perfect. Thank you. Okay. So I guess it's back before us now for any questions for staff or the applicant.
Mr. Chair.
Commissioner Mooney.
Got a question about for staff regarding the detached sidewalks. The way I understand it is the applicant just stated that there's only one other example, the lube shop, I think, nearby, and there wasn't any other. But as I recall, we just approved one with the detached sidewalk caddy corner at 2315 Broadway. Is that true?
Mr. Chair, members of the commission, you are correct. I think just right across the street, there was a multifamily project that went in that was proposing detached sidewalks.
Which has been approved, right?
Which was approved,
Okay.
I think last month, actually.
Mr. Chair.
Yeah, please, John.
So follow up regarding that application also preserved a historic building.
Mr. Chair, members of the commission, that is correct. That building did, or that project did preserve the old house on it.
So in this application, the applicant conducted an analysis of the building, but he also stated that he asked for the formal inspection reports, but I don't see any formal inspection reports in our packet.
Mr. Chair, members of the commission, I did ask for them. I received a summarized report that you received. I didn't receive the actual formal ones.
Mr. Chair.
Please.
Yeah, that summary was kind of informal from my perspective. It was lacking from my perspective. So that I just wanted to point that out. Thank you, Mr. Chair.
Mr. Chair.
Commissioner Moore?
So this is a question for the staff. Is there an approved application for that property to the south, or is that still vacant?
Mr. Chair, members of the commission, that is still vacant.
Mr. Chair.
Please.
So for the other side, on the north, the proposed access point is pretty close to Broadway. Is that a requirement? That's a requirement from the DA?
Mr. Chair, members of the commission, the DA required cross-access be provided to the north, which is the credit union. That is an existing access point that they're continuing to use. The site currently has a day spa and office on it, and I believe that is where their access point currently is. And they're going to continue to utilize that at that point. And they're sharing the access point on the Broadway on the property with the property to the north.
Sure. Thank you.
Mr. Chairman.
Commissioner Daly.
Questions for staff. As far as I've seen, I don't think I recall, and I'm looking again, I don't see any letter from ITD. Is that correct?
Mr. Chair, members of the commission, that is correct. They did not respond.
Why on earth is our state agency who's responsible for this gateway corridor not commenting on this application with respect to the pedestrian issue, whether it's access issues, whatever the case may be? I mean, can we explain that at all?
Mr. Chair, members of the
Mr.
commission.
Moser can't, but somebody.
It is true that they did not respond, although the staff did reach out to them on this matter, or at least in concerns with like pedestrian access and things of that nature. And based on our conversations with them, although it was not formal, they would be willing to consider pedestrian path or some type of access or crossing over Broadway in this area, but it's something that would have to be worked out. But they did not formally comment on this application.
Okay,
It's going to read as audible sighs in the transcript. There's rocks falling on Highway 55.
That's why they have
constantly, okay?
District
Come on.
3, because District 3 oversees this area and they're about 7 miles away. As a follow-up, if I may, Mr.
Please.
Chairman.
Yep.
So you touched on it, David, about the crossing. And I know that for me, that without a doubt is paramount here. The applicant is getting a bonus. They are benefiting from our code that allows more units and fewer parking stalls because of the transit access. But getting the residents to and from those bus stops is not part of the equation here. ACHD is collecting an impact fee. I'm sure you guys are thrilled about that cost, right? Guess what? It cannot go toward pedestrian impacts. So my question, I guess, is what mechanism do we have as a city to be thinking about these issues, to get folks, when we have an application that does qualify for these improvements because of the access to transit, to get people back and forth safely?
Mr. Chair, members of the commission, it's a very good point, and it is something that definitely needs to be addressed. Based on our conversations with ITD, trying to get a pedestrian access over or across Broadway in this area is definitely a much larger process and requires a lot of work between the interagencies and trying to get it cited right. So it's going to take a lot of work. How do we do this, with these type of applications? That is a very good question. We sometimes run into issues with the sort of offsite improvements, or if it's too offsite, or depending on what's required, there's also sort of a proportionality aspect that needs to be considered regarding conditions. But it's something the staff needs to consider and try to figure out. I don't have a solution, unfortunately.
Mr. Chairman.
Yeah, please.
And this gets into the system that we have. because we can't, the whole notion of requiring a pedestrian improvement, even if it's 100 foot away, technically it's off-site, but you pay an impact fee for a system-wide improvement, and this application is on a state highway that doesn't even get the impact fee because it's ACHD who collects it and disperses it. And I bet you there's not a project within 3 miles of this particular application. There's the disconnect that we have. And so the notion of having a gateway plan, I mean, this is a gateway corridor, right? And getting to it is something that I would hope that we could continue to explore for this very, not just this application, of course, but as this corridor and others start to transition to what we're seeing and take advantage of this code, that we have for this very purpose is something that I think we need to should happen yesterday, right?
Mr. Chair, members of the commission understood. I think the staff realizes that and is taking that into heart, particularly with the code rewrite.
Okay. I got a couple questions, David. I'm guessing I'm really looking over the site plan. Is the property line right at the back of the sidewalk? More or less?
Yeah, Mr. Chair, members of the commission, more or less, it's 10 feet from the building to the back of the sidewalk. And that's essentially, that is basically where the property line is.
Okay, great. Do you happen to know, David, like Broadway, I struggle with Broadway and Vista and State Street and these, attached conditions, and we always want detached conditions with the sidewalks. Do you happen to know, like adjacent north, right, where the credit union building is that sidewalk a 5-foot sidewalk, 7-foot sidewalk? Do you happen to know?
Mr. Chair, members of the commission, offhand for the bank, I would hope that it would be a 7-foot. It's a relatively, that was built probably about 6 or 7 years ago.
Mhm.
So offhand, I don't know.
Okay. All right. And actually, John, if you don't mind stepping up, I have a couple of questions. Okay, thanks. So on the sidewalk issue, I don't disagree with you that it's nice having landscape between the sidewalk and the building right now. If this body decides tonight that we want to detach the sidewalk, would you consider, how would you react to that? I guess, would you consider narrowing the building or shifting that building or picking up a little more space, or would you carry on with sidewalk 4 feet from the building?
That's a good question. If you look at the site, we have to accommodate that cross-access easement,
Mhm.
and then we have the building, and then we have the back property line. So we're really trying to, we really are kind of pinched all across the site on this. I don't think we can move the building. We have looked at it, but the units are really getting just tighter. Like I said, we could accommodate it. I just think it's going to be design-wise. We just feel it's consistent with what's going up and down Broadway all the way, even the new developments. You can look. That is the only one that is on there for that 2.1 mile section, the detached piece. We also think it'll just provide a little better screening there for the car and just a little bit more pleasant corridor. And I think the sidewalk at the credit union is 5 feet. So we'd be happy. We intend to make it 7. We could even make it slightly more. We just like that buffer. I think it just gives those units a little bit of privacy. I think it just gives a little more appeal to just to the street there.
Okay, great. Okay, thanks. I had one more question for you too while we're at it. We had a couple of comments in our packet about trash service, size of the enclosure. Did you guys study that much at all? Or, it looks like you have space to put in a bigger enclosure if need be.
Yes, we did. Yeah, we upsized. Let me see exactly. Yeah, we responded to all the comments and made those adjustments.
Okay.
So that one has been made. Yeah, and then we shifted it to where it's more accessible, kind of right there.
Okay.
Right in front.
Yeah, right off the drive. Okay, great. All right, thanks. Any other questions?
Mr. Chair.
Commissioner Mooney.
There was some concern in the packet from testimony from the neighborhood regarding overflow parking in the credit union, as well as cut through traffic over to the park down Rollins Street. So question for you, David. When the parcel north of the credit union develops, is it true that we plan to put in a multi-use path there and basically install pedestrian bicycle access down Rollins Street to the park?
Mr. Chair, members of the commission, when the parcel to the north of the credit union develops, there is a pedestrian access easement across that site with a gate through that back fence into that neighborhood so that people on this side could easily or greater access Ivy Wild Park in that neighborhood with more ease instead of walking a great distance down and around. So that is true that that development will include that and that pedestrian access easements in place.
Thank you.
Okay. All right. Looks like we're done with questions. We'll go ahead and open up public testimony on this item. Number 7. No one signed up in advance. If you're here to testify on this item, please come on up. Okay. Anybody on the line? Oh yeah, Mr. Berg. That's right. Eric would like to testify.
Thank you, Chair and Commissioners. I've lived in this area for 10 years now, and I really can't think of a time I've been more excited about a lot of the projects coming down the pipe for Broadway. This one included. More residential density along this corridor has been desperately needed, and it's a perfect use for this part of town. I absolutely support this project and can't wait to meet our new neighbors, but I also implore you to require the project to be approved with the conditions the city asked for. Having said that, as the applicant has indicated, if they are willing to do a 7-foot sidewalk, my biggest concern with there being a detached sidewalk and for there being a landscape barrier is to make sure that we can have the ITD pedestrian hybrid beacon that according to their standards would be suggested for a situation like this. And my concern with a 5-foot sidewalk is between that, a bus stop, and the steel structure required, it would be pretty difficult to fit all that. So I'll defer to the commission and ITD and everyone's assessment on whether that would still be possible with the wider sidewalk. But between that, and as long as there's not a wall up against the sidewalk, which is also a concern for pedestrian safety, as long as there's a landscape on one or the other side, I think that will be a great asset to move pedestrians up and down Broadway. And I really am excited for this asset to the community. And also want to thank David for being incredibly helpful through all this process.
Thank you, Mr. Berg. If you wouldn't mind giving us your address for the record, please.
Sorry, 1301 South Grant Ave.
Great. Thank you very much. Okay, I think we had another hand up online. Okay, good to go. Mr. Dietrich.
Good evening. My name is John Dietrich, address 861 West Rollins Street. Thank you for allowing me the opportunity to speak today. Before I share my comments, I would like to say that I'm very supportive of constructing new multifamily properties with adequate parking throughout the area, and I do appreciate the developer looking for opportunities to bring desperately needed housing options to Boise. That said, I do want to pass along some very serious safety concerns I have with the proposed development, most of which were provided in a letter to Mr. Moser on April 25th that was signed by residents of Hereford Place and Carnation Townhouse subdivisions adjacent to the proposed new development. I have great concerns with constructing a 35-unit apartment complex on less than an acre of land that only provides 37 parking spaces. The developer is claiming a reduction of 2 spaces due to being within 1,320 feet of a city bus stop. And while the northbound stop is clearly within that distance, as Commissioner Delaney pointed out, the southbound stop is directly across Broadway with the closest crosswalks either 1,000+ feet to the south at Linden Street or a similar distance north at Iowa Street, making the total walking distance from the southbound stop at well over 2,000 feet. Therefore, at a minimum, this 2-space reduction must be denied. This complex is not proposed to be low-income housing, rather will most likely command rents at or above current Boise rates, and it is not in proximity to much besides a few restaurants, automotive shops, and coffee stands, with the only grocery store over a mile away and BSU 1.5 miles away. Based on these factors, it is hard to conceive that some units will not have a car, and logically many units will have at least 2 vehicles. Even if each unit only has 1 vehicle, that leaves only 2 additional non-ADA spots for the superintendent, mail service, package deliveries, maintenance vehicles, any guests, which we know will be woefully inadequate. This is compounded as there is zero available parking anywhere within proximity of the proposed development. No street parking on South Broadway, no pay to park lots anywhere, just the credit union, which is clearly private parking. The only on-street parking is on the west side of South Broadway, which when utilized will create quite a safety hazard, as folks will have to jaywalk as they have no other parking options close by, or go down to the crosswalks, which we know is not practical. And the safety concern becomes exponentially larger as a different developer is proposing another 40-unit development just north of the credit union with only 45 spots. If both of these are built, this will create 75 new living units with only 77 non-ADA parking places to be built along this 5-lane arterial with no proximate parking options. So the question I implore you to have the developer adequately answer is, where will overflow vehicles park? The commission must require them to have a plan that is sufficient to eliminate the safety events that will surely come if this development is allowed to proceed. The design standard that they are following surely did not anticipate multifamily housing along a gateway street. Rather, I believe it was written for downtown locations or within a residential community that has an abundance of available street parking or paid parking lots. The same standard cannot apply here along South Broadway, and you all have a responsibility to consider all of these factors before approving new development. Therefore, if the developer cannot answer the question as to overflow parking, you must require them to build a garage, acquire the lot to the south, or reduce the number of units in the complex such that development matches expected occupancy. Thank you for your time.
Thank you. Okay, I think that does it. Sorry. That does it for the folks online. Then we can bring the applicant back up for rebuttal at this point.
Mr. Chair, members of the commission. Just wanted to address the comments. David, I think you got to thank you. Staff's always very helpful to us in kind of working through these things. You know, they are complicated. There's a lot to consider. And I think, you know, they have been very helpful, as they always are, on offering guidance and, you know, helping us kind of find the right solutions. To John Dietrich's comment, parking, you know, we do meet the standard. We are not asking for any extra reductions there. There is a bus stop within 300 feet on the south side. It's just a half block past the credit union. And that's all I have to say there. Thank you.
Okay, thank you. Okay, we'll bring this item back before the commission to render a decision. Again, we're talking about PUD 22-21.
Mr. Chair,
Commissioner Moore.
I move that we approve PUD 22-21 with all the terms and conditions as stated in the staff report.
Second.
That a motion to approve from Commissioner Moore and a second from Commissioner Blanchard.
Correct.
Jennifer, you want to start us out?
Absolutely. So the detached sidewalk, I'm looking at our kind of aerial view and seeing a vacant lawn to the south and then the credit union and a vacant lawn to the north. I think those two lots are good reasons to have a detached sidewalk, because then you get a very large section of Broadway with detached sidewalk. I think the attached sidewalk on Broadway, those cars are going relatively quickly. And it just helps protect pedestrians. And just with those vacant lots, you know, there's obviously redevelopment that will happen eventually. So it makes sense to kind of recess that, even if it is the exception and not the rule now, that doesn't mean that that's always going to be the case. So I think it does make sense in this particular location to require that. I know that it could affect the trees. Looking at some of the images, you know, those two lots in particular don't have any trees that I can see. And then the subject lot has a couple trees, but you know, comparatively, it's relatively minor. So I'm reasonably comfortable with that. Especially on top of that, we're demolishing the existing house, so it is turning into a blank slate of a lot. So there's no hardship in my mind, with the exception of just the way Broadway is, to really require, to not require, I guess, the attached. Other than that, I think otherwise, I think, it's a step in the right direction. Getting a little bit of multifamily, I think it provides a variety of housing types with the smaller units in this area. And I think it's a good addition.
Okay, thank you. Any other comments? No.
Mr. Chairman.
Commissioner Glassby.
So I'll be strongly supporting the motion. I wanted to address the comments about parking and the sidewalk.
Okay.
So with respect to parking, it's clear policy intent of the city to reduce parking requirements. The city council passed these new parking requirements and all these bonuses. The applicant is availing themselves of those decisions. I strongly support both the policy and allowing the applicant to do what the code says that they can do. So I'm delighted to see us not enforcing such heavy parking requirements, which is a huge driver of the cost of housing and is very inequitable in how it affects different groups of our society. So I'm really in favor of both the policy and the application. With respect to the sidewalks, I'm not strong one way or the other. I agree with Commissioner Moore's comments that I don't think we'll end up creating a stranded detached sidewalk here. I think there's a lot of redevelopment. And my understanding is that we really want detached sidewalks on these showcase streets because we want people to start walking up and down the streets again like they used to. And Broadway is one of those. So I support Commissioner Moore's motion.
Yep. Thanks, Commissioner Glassby. Any other comments?
Mr. Chair.
Commissioner Moody.
I'm in support of the motion as well and appreciate the effort, but I also am kind of concerned about the comments that Commissioner Danley brought up and our disconnect with ITD. Is there anything we can do to make it safer for, in particular, bicyclists? We condition the application for the applicant's got to install 35 spots. Some have to be covered. We've got all kinds of code requirements, and yet there is no way to get a bicycle out of that location safely. It doesn't make any sense why we do that to the applicant. I guess that's I'm just ranting. I don't have
something to think about later.
I have an answer, but it becomes political very quickly, which is yeah. So she says no.
I think Commissioner Danley's got some comments. If I can't
tell. Bear with me. So I am in support of the project, but I will be voting against the application. And I know that makes no sense at all, but here's why. So every single year for the last several years, we've been teaching a class on walkability. And at the conclusion of that class, we end with a slide that's on Broadway. And this class has been taught all over the country. And it specifically is from 2 blocks to the south of this spot, where a man named Ray Oliger was killed about 8:30 at night, about 5 or 6 years ago, crossing Broadway. And when we show that slide, the reason we do it is because we demonstrate that there were approximately 7 or 8 different specific action steps that could have been taken to prevent his death. When so often is the case, we collectively throw our hands up and just say, it was an accident. Nothing could have been done. Tragedy yet again. When in fact, absolutely something could have been done. Last year, December 2021, a document came out from the American Association of State and Highway and Transportation Officials. That's the governing body of traffic organization or traffic engineers. Guide for the planning, design, and operation of pedestrian facilities. You know who was on the committee to create that? 2 members from ITD who signed their name to it. And when they did create that document, there were numerous recommendations. One of those was regarding frequency. I'll tell you, I read it verbatim. Unlike motor vehicles, pedestrians cannot be expected to go more than half a block out of their way, about 300 feet, in urban areas to take advantage of controlled intersections. Specifically, then they give two particular elements or two pieces when it comes to locating mid-block crossings. They say where spacing between adjacent signalized intersection exceeds 600 feet and at a mid-block transit stop. Both of those are applicable here. The nearest two crossings marked signalized are at Iowa and Linden. One's 850, one's 1,000 feet away. Everything about this application screams exactly what ITD signed on the line to support and said, nope, we need to be doing it a different way. But we don't have the mechanism in place to do it the different way. So I cannot, in good conscience, support an application that is taking advantage of our policy for transit access, which I fully support, without providing the safe crossing to get those folks back and forth. If we're going to take advantage and benefit from that same policy, then I think that we need to figure out how to keep them safe. I think that's a pretty fundamental piece. So I can't support that. I don't know how to solve that. And it frustrates me and it angers me because I don't think that the applicant should be the one to pay for the entire pedestrian hybrid beacon that would solve this issue. We are going to see additional developments along this corridor. I'm confident of that. And I think it should be a shared burden because it's going to be a shared facility, but we don't have the mechanism in place. Last piece with regard to the detached sidewalks, 100% we need detached sidewalks on here, especially if you're going to maintain a wall. Because again, guidance says if you have a wall next to a sidewalk, the first 1.5 feet of that space is not usable because we do not walk like this. It's as simple as that. So if we have sidewalk, wall, and a curb, by the way, the curb has the exact same science behind it, 1.5 feet by the curb. So basically 7 feet becomes about 4. That's what happens when you put people up against 35-mile-an-hour traffic and a wall. So you have to detach this. That's the science behind it. And it's exactly why the city is doing it. And I applaud the city for that's a lot of things I know, but this is my string man, right? You all know that.
All right. Thank you, Commissioner Danley. Okay, any other comments? All right, let's go ahead and move on to the vote. PUD 22-21, we have a motion to approve from Commissioner Moore with a second by Commissioner Blanchard. Will the clerk please call the roll?
Schaefer,
Yes.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Danley,
No.
Mooney.
Aye.
6 in favor, 1 opposed, motion carries.
Okay, thanks. All right, moving on. Original item number 8, PUD 22-22 and CBA 22-7, Kimley Horn, project address 5102 and 5122 West State Street. Conditional use permit for a planned residential development comprised of 48 multifamily units on 1.2 acres in a C2D zone. And we're going to hear from staff first. Mr. David Mosier again.
Thank you, Mr. Chair, members of the commission. As you've just noted, the applicant is requesting a conditional use permit for a planned residential development comprised of 45 multifamily units located at 5102 and 5122 West State Street on approximately 1.2 acres in a C2D zone. As you can see here, the property is located along the north side of State Street between Market Lane and North Street and across from the Lake Harbor development. The surrounding uses include office, small-scale commercial, multifamily residential, and single-family homes. It is also located approximately 1/2 mile from the Greenbelt pathway along the Boise River to the west. As you can see from the site plan here, the development consists of one 4-story multifamily building containing a mix of studio, 1- and 2-bedroom units. The project proposes 45 dwelling units with a density of about 37.5 units per acre, and the C2 zone supports up to 43.5. With the exception of the variances, the project will comply with all the setbacks, building height, and provides all the required parking. There is a hardship and an exceptional circumstance associated with the property, which is the odd configuration of the parcel and an irrigation canal owned by the Boise Valley Ditch Company runs along the rear of the property line. In summary, It complies with all the required findings and standards as per the development code for the PUD and the variance, which includes also the 12-foot wide multi-use path that they're proposing along State Street. I would note that the planning team is recommending two changes to two conditions of approval from the project report. The first change is to condition number 2. This modified condition still requires the applicant to provide cross access to the adjacent properties, which can be noted on this plan here to the north, or to the west, and to the south. The second change is to condition number 3, which will add an additional encroachment of 2 feet into the required 5-foot setback along the east or southeast property line, which is identified right here. It's basically the 5-foot required landscape buffer by code. It's essentially 5 feet up at the road, but given since the parcel's not exactly a square, it pinches out and drops below that 5 feet standard as you go north or northwest, I guess. The hardship and exceptional circumstance associated with this additional variance is the same as the other variances discussed within the report and the project report. Changes to these conditions of approval are discussed in the late correspondence, and the wording of the two conditions are listed here. Finally, the adjacent property owner submitted a letter of opposition expressing concerns regarding the location of the southeast property line as shown on the site plan, and they maintain that the location of the southeast property line on the site plan is not correct. However, the documentation provided by the applicant matches the most recent record of survey on file at Ada County from 2019. This slide here shows that record of survey on file at Ada County next to the site plan, and they're the same. If there is a disagreement on the location of the property line or differing project or records of survey on file that show different property line locations, it's a civil matter. But the site plan they provided is consistent with the most current record of survey. In conclusion, the planning team recommends approval of the PUD variance. Thank you.
Thanks, David. Okay, next we'll hear from the applicant. I think Nicolette is online, or do we come up in person first? All right.
Brandon McDougald, address is 1100 West Idaho Street, Boise, Idaho 83702. And David,
Give a clicker.
do I have the, I do?
Yep, I should work.
Okay, fantastic. All right. Just wanted to thank David for that overview of the project. I think that was, it talked through a lot of the things that I wanted to, and I might just reiterate a few of the points as we get through it. But tonight we have a few individuals that are here both in person and virtually. So just a slide of the applicant team. I'm Brandon McDougald, Nicolette's on virtually, and I think we have the developer that might be online as well. The developer is Cedar and Sage, local developer here in the Treasure Valley. They've got several projects that they're doing here in the Treasure Valley and multiple projects throughout the Pacific Northwest. Here's just a couple of projects that they've done recently in the Pacific Northwest, one in Richland, Washington, and another one in Cincadia, Washington. The project that we're hearing tonight is what's identified in red. This is a vicinity map just right off of State Street and Market Lane. Just to give you a little snapshot of the timeline that we've had on this project. So we had a pre-application meeting with the city in September of last year, followed by a neighborhood meeting in February of this year. We submitted an application that same month, and we're hearing the project tonight. As David indicated, just a quick little recap of the project. We've got an irregular shaped property. It's about 1.2 acres. There's 2 parcels that make up that 1.2 acres. We've got a 48-unit multifamily apartment building, 4 stories, and a mix of different product types with 16 one-bedrooms, 16 two-bedrooms, and 16 studio apartments. We have a single access off of State Street, and have also provided for a 12-foot multi-use pathway that is detached off the existing curb and gutter right now along State Street. I guess one thing that I just reiterate that we have met all the parking requirements by city code as well. Just a couple of snapshots of the elevations. The front elevation facing State Street is there on the top, and then the back elevation that faces the parking lot. And this is just a slide that just summarizes the conditions of approval. We are in agreement with all of the conditions of approval. As David indicated, the concern with the adjacent property owner and concerns about property lines. There is the final condition of approval requires us to go through a parcel consolidation, which would require a record of survey. I think that considering that is a condition of approval, that will certainly be vetted out through that process. And I guess we are asking the requested action is approval of planned unit development and variance, and stand ready for any questions that you may have. Thank you.
Thank you, Mr. McDougald. Let's see if we've got anybody from the Collister Neighborhood Association with us. Don't think we do. So we'll move right along into questions of the applicant or of staff. Okay, no takers.
Mr. Chairman.
Commissioner Gillespie.
David, could you throw up the map? I couldn't find it this morning or right now that shows where the variance requests are. That's pretty small.
Mr. Chair, members of the commission, the variance requests. There is a variance request from the building from the side setback here along Market Street, which is actually a private property that it's a large parcel that has, I think, an office or like a daycare directly adjacent to it, zone C2, but it's also one parcel and it contains the apartment complex. The C2 zone, when you're adjacent to a residential use, requires a 10-foot setback, and this building is at 5 feet here. So this is one variance request. Since that's also a residential use adjacent to basically the northwest, the C2 zone requires a 10-foot parking setback. This parking right here is encroaching into that 10-foot setback. So this area right here is a variance request. Obviously, the parking circulation along the back property line is definitely in the setback. Probably encroaching almost to like 1 foot of the rear property line. And then, as mentioned, this 5-foot landscape buffer right about here, although you can see it pinches out as you go this direction and gets down to about a 3-foot landscape buffer. So there's a variance request here. So 3 variance requests for the parking around the perimeter of it, and then 1 variance request for the building to encroach into the side setback.
Mr. Chairman. Nope. So I'll leave it for the commission to decide if in fact there's a hardship created by the shape of this lot. I mean, it's not perfectly square, and there is that canal easement on the, I guess, the northeast side. And there is that little flange of property sticking way down there. But I'm not sure any of those issues, those what do we want to call them? Irregularities in the shape of the lot justify putting a really big building, right against or very, very close to the property line. And so I'm struggling again with just the setback issue again. And I'm going to raise the question of why do you think this site is big enough if it has to, fill in all the setbacks?
Mr. Chair, members of the commission, as for the variance on the building, I think if this directly adjacent to it to the northwest is a C2 zone and is also, I think, a office or type of use. If this was its own parcel, this would be a 0-foot setback, but because it's all one parcel with the adjacent that contains the apartment buildings, we're being conservative and applying as a residential use there. There is flexibility if you wish that this building could possibly jog this direction over. There's 8 feet on this side. So there is flexibility to possibly move that building over and have it comply with the setbacks, although I'll let the applicant determine whether or not that's feasible.
Mr. Chairman.
Yeah, please.
So the easiest way to formulate my question is you got a big piece of flat ground. How come you can't stay within the setbacks?
Yeah, great question. I guess one thing that I would point out is there was a similar project that was approved not too long ago, multifamily project, and they also needed variances in order to get that project approved. So it's a challenging site, irregularly shaped, and then just trying to provide a multifamily project here adjacent to State Street. Hard to do without variances.
Mr. Chair,
Commissioner Mooney.
I got a question for, I think staff might be applicant as well. I'm trying to understand the transportation analysis from ACHD. And their report is from 2019, which basically stated there are no State Street improvements, and yet this application has State Street improvements, including a multi-use path. So how are we supposed to think about that piece of the puzzle and the 62 feet from center line right away? Is that all factored into this?
Mr. Chair, members of the commission, the Highway District, and I did actually reach out to the planner at ACHD who worked on this. They essentially used the same project report that they issued for the previous planning application, multifamily application that was submitted back in 2018, and just submitted a cover letter saying it all applies. I did ask them to respond on the multi-use path, since that is a site on-site improvement or along the street that the report didn't discuss. And the response I got back was, well, it's larger than a normal sidewalk, so we're in support of it. So they're not in opposition to the multi-use path within their right of way. But you are correct. The project report that they submit is an old one, and they just chose to resubmit it for this project, assuming that the two applications are similar enough. Although I think the dedication will be the same. I figured they would have got that correct. And I believe the applicant did work that into their project.
Thank you.
Okay, any other questions?
Mr. Chair, I'm sorry. I should.
Yeah, no. Go ahead, John.
So did that include the 6-inch center line median for right in, right out? That was one of my confusion items from the ACHD report. I don't know who that's for either.
Yes, that is a condition of the ACHD approval, is to put in a 6-inch median within State Street. So we'd comply with that.
Great, thank you.
Mr. Chair.
Commissioner Moore.
So I think I don't, and it doesn't matter who the question is for. To clarify, I'm looking at the aerial map again. Is the canal tiled or is it open air? Brendan, that'd be great.
Assume it's going to be tiled.
It's open air at the moment, but it will be tiled through this, a portion of the site. And then, so I'd say about half of it's going to be tiled and half of it will remain open.
Okay. Is that it for questions? All right, very good. We'll go ahead. Thanks. We'll go ahead and move on to testimony. Anybody here in person like to testify? Come on up to the podium. Name and address for the record, please. You have 3 minutes.
Good evening. My name is Christopher Sleddy. I'm with the law firm Johnson May. Our address is 199 North Capitol Boulevard, Suite 200, Boise 83702. We are counsel for Granite Counters LLC and Ben Kalkman. That is the property to the southeast of which the variance is being sought, located at 5032 West State. We oppose the application as is currently proposed. As the issue has been pointed out, there is a variance being sought. It's our opinion that there are 2 surveys that are kind of fighting with one another. We believe one is erroneous and demonstrates that there is an overlap onto my client's property. At this point, we just oppose that and want it on the record.
Okay.
Question?
Right. Thank you. Yeah, anybody else would like to testify? Nope. Okay. No hands up online. Okay. Applicant, you have a few minutes for rebuttal if you'd like to take it. Okay. Let the record show that the applicant has yielded his rebuttal time, and that will therefore bring this back before the commission to render a decision. And we're talking about PUD 22 and CVA 22, PUD 22-22 and CVA 22-7.
Mr. Chairman,
Commissioner Gillespie.
move we approve PUD 22-22 and CVA 22-7 with all the terms and conditions in the staff report. Plus, didn't we get a bunch suggested to?
Yeah, we had condition. Yeah, we had a reminder for conditions number 2 and 3
with the conditions as proposed by the city 2 and 3.
Second.
Okay, we got a motion to approve from Commissioner Gillespie and a second from Commissioner Squires. Millet, you want to kick us off?
Yes, Mr. Chairman, Crystal, does the city have what it needs? Okay. So first of all, more density on State Street. I'm for it. I like the project. It does a lot of things that the Chris's want to do. It's, on State Street, parking's in the back. It's got nice shrubs and stuff. No meandering path. That I'm sure we need more signal beacons on State Street, and we can't figure out how to do that, but that's for another day. So I'm supportive of the project. The only way we're going to improve mass transit on State Street is to have the transit. I'm not super happy about the little variances. Sometimes I feel like you guys nibble away at me, nibble 2 or 3 feet here. Like it says 10 feet in the code, fit the damn thing into 10 feet. But nevertheless, I do agree that this is a site with no right angles, and people like to build parking lots and buildings with right angles. And so when that's the case, we get these little pinches. And so in this particular case, I agree with the statement of hardship. Wish we'd work a little bit harder sometimes to fix those, but I understand that. So that's why I made the motion.
Okay. Thanks, Milt.
Mr. Chairman.
Mr. Squires.
I agree with Milt, Commissioner Gillespie. It's a great use for an underutilized site. Been driving by this for years. It's nice to actually see something happen with it. I also had the same concerns with the variances. It felt a little self-created in some instances, but I do think we can make the findings based on all the reasons that Commissioner Gillespie just outlined. I think the boundary issue will be resolved through the conditions of approval. And again, this is a new urban renewal district. It's a transit-oriented development. Again, we need density to support it, and happy to be able to do so.
Okay, any other comments? All right, very good. We got a motion from Commissioner Gillespie and a second from Commissioner Squires to approve PUD 2222 and CVA 22-7 with the terms and conditions of the staff report with the recommended amendments to conditions number 2 and conditions number 3 that staff detailed at the beginning of the presentation. With that, will the clerk please call the roll?
Schaefer,
Yes.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Aye.
Finley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay, great. Thanks.
Mr. Chairman.
Commissioner Gillespie.
So, point of order typey question. I vote we do number 9, but I don't think we're going to get to number 12 tonight because these guys really want us to get through 12.
Okay. We got a room
All
full.
right.
All right, we got a room full for 12.
Okay.
So
Yeah.
okay.
See how it goes.
All right. Well, we're gonna cruise through number 9, then cruise through number 12. Okay. Right. We're up to number 9, originally number 9, CAR 21-32 Hatch Design Architecture 6780 South Cole Road. Annexation of 2.2 acres with a C2D DA. Sabrina Mortensen from staff.
All right, Mr. Chair, members of the commission, the next item before you is a request to annex approximately 2.2 acres located at 6780 South Cole Road with a zoning designation of C2D DA. The subject site is bordered by parcels within the city of Boise limits on 3 sides, meaning that services are already available in the area and the annexation will have a minimal financial impact. The proposed C2D zone designation is consistent with the planned community land use designation of the comprehensive plan. Blueprint Boise encourages clustering new commercial uses within the Southwest planning area in specific locations, including areas within the reserve planned community. The proposed development agreement would prohibit certain auto-oriented commercial uses such as drive-through establishments and surface parking lots, which are typically allowed outright in the C2 zone in order to promote more community scale use of the property. The DA also requires the site to take access from a shared access point located on the adjacent parcel to the south in order to consolidate access to the adjacent arterial roadway and reduce the number of potential collision points. Written comments were received from 2 neighbors of the property who expressed opposition to the proposed annexation. Their concerns are summarized on this slide, and the majority of these concerns are directly related to the self-storage use that is proposed by the applicant. However, self-storage is a conditional use within the C2 zone. The compatibility of the proposed use and the feasibility of mitigating any possible negative impacts would be evaluated at the time of a future conditional use permit application. In conclusion, the planning team recommends approval of the annexation and the associated development agreement, and I'll stand for any questions.
Okay, thank you, Sabrina. Next, we hear from the applicant.
Jeff Hatch, Hatch Design Architecture. Our address is 200 West 36th Street in Boise, Idaho. Good evening, Commissioner Schaefer and fellow commissioners. Thank you for your consideration of our annexation application this evening. Is it the red one? Nope. Let's go that. Okay. So as Sabrina had mentioned, we have a recreational storage facility, primarily outdoor, kind of large format self-storage. Location is mostly surrounded by residential developments. We do have a canal to the east of us and a single family residence also owned by the same property owner of this property to the south of us. Some of the, I guess the summary of the conditions of approval as a recap was really looking down at the feasibility of the project based on the utilities and the streets. Our comments about schools. They deemed that the project was feasible for annexation. Some of the considerations that we had from our neighborhood meeting and comments that we received in letter format was concerned for other storage facilities in this area. We're geared for recreational large format storage versus the smaller self-storage that's mentioned. There were concerns about light pollution, which will meet city code as well as dark sky compliance. And as far as traffic, there was some concerns. And from ACHD's impact fee generation, which is based on traffic, storage has the lowest traffic rating. And since these are larger parking spaces, we would have even lower than your standard traditional self-storage. There were some comments and concerns about protecting the canal, which you see that as to be a valid concern. So we would want to make sure that all of our stormwater retention is on site and engineered and designed by a civil engineer. There was potential properties for other concerns for just being adjacent for residents to commercial. And our case in point, we're working on Hazelwood Marketplace, which is to the west of this. And most of the neighbors around there are ecstatic. If anything, they want more amenities on this side of Boise. So we're excited to bring this opportunity and hoping that in the future, the balance of the property to the south can have other commercial amenities for this area. There was one consideration that we spoke very, very early on with Austin Miller and Paige at ACHD about access, because access is always a concern, especially up against an intersection from a safety standpoint. From our conversations and our staff report from ACHD, they were in support of the proposed access on our current proposed property. The existing access for a single family residence is down here. And in talking with ACHD, they felt comfortable with the proposed location based on the use. The use is residential storage, it's low density use, and the location works well for that because you're in the deceleration lane for that. As the property to the south gets redeveloped, they intend to extend an access point that would be in line with the subdivision to the west, which would meet the intent of ACHD. So the one condition or consideration that I'd like to present to the commission would be in that development agreement, if you would consider rewording or amending item number 4, which speaks to the requirement of utilizing the existing access. And we would just rather encumber the property to the south, which is owned by the same development, for a safer development in the future. Any future access or intensity of traffic that we put on this for the future could be a safety concern, which we wouldn't want that to be the intent. ACHD understands that, and our staff report from ACHD supported that concern. And so that would be the consideration. And with that, I'll stand for any questions.
Okay, sit tight for questions. We'll check in first, see if we have someone from South Cole Neighborhood Association with us. Doesn't look like we do. Okay, we'll go ahead. You don't want to ask any questions? Okay. All right, team. Yeah. All right, we're up.
Mr. Chair.
Commissioner Moore.
This is a question for the applicant. Can you explain where the DA wants the shared access, or what the shared access that you're talking about? Is it at the property line or the shared property line?
Good question. So currently, and Sabrina, correct me if I'm wrong, the proposed access for the development agreement would be on an entirely different property that happens to be owned by the same property owner. So we're already encumbering an adjacent property for access to a separate property. All we're saying is in talking to ACHD, who looks at this very critically from both a safety standpoint and also an access standpoint, and usually we're negotiating this discussion with them. I was very surprised to get this feedback from the city of Boise. So I just wanted to reiterate what comments we're getting back from the highway district, which is instead of intensifying this access, which doesn't align with the current access, they would rather limit this to a very low intensity traffic format and then align in the future with the property to the west, which is what they typically like to do, is have their accesses align with the already existing subdivision to the west. Is that clear, Commissioner Gillespie?
Mr. Chairman?
Yeah. No.
So I'm a little confused though. So, okay. So you want to put in the north access point directly onto the property, is that right?
As proposed and as recommended by ACHD, yes.
Right. And is not recommended by the city at this point.
Correct.
And you're anticipating at some point that ACHD is going to push that the next access point down south. They're going to move it and align it with a cross street further south. Is that what you're saying?
The feedback that we're getting from ACHD, that would be correct. Currently, there are 2 existing access points, the one for the existing residents and approximately the same location that we currently propose for our access.
But then so are you saying now that then someday someone rolls in and wants to put in multifamily housing, because that's what happens in Boise apparently. And where do they take access then? Off that new far southern access point, and there's a cross access all the way up? Is that what you think should happen? Or would it, I'm just a little confused as to like how this plays out and what your reasoning is.
Great question.
I didn't kind of get, you said something and I didn't get it.
Yeah. So the property to the north,
the one we're talking about,
the one that the application is for, the annexation is for, would have its own access, not accessible from the property to the south, as currently proposed. The current existing access for the residents could stay, or if we need to modify that access, and both from ACHD standpoint and also from a safety standpoint, it's going to be a safer access to not intensify this access any further than it already is.
Mr. Chairman?
Yeah, please, Mo.
Wonder if the city has a point of view on this issue. Have you guys discussed this already? And if so, what's the city's point of view?
Yeah, Mr. Chair, Commissioner Gillespie, the applicant and I have had a little bit of discussion, and I know we have kind of through this whole process. The city's perspective on this is that it's ideal to consolidate the number of access points coming off of an arterial, and that we do want that to be located as far south from the intersection as possible to minimize the potential for traffic coming in and out of the site to conflict with traffic stacking up at that intersection. Another concern we have with maintaining a separate access point for that northern lot is that as written, the development agreement doesn't tie that lot to the self-storage use. There are a number of other uses in the C2 zone that could potentially go in there that would generate more traffic. And so having that close to the intersection wouldn't be ideal.
Mr. Chairman?
Yeah, please, Mo.
So if we let you have that northern access, will you promise in the DA agreement that if a future user wants to intensify that use, they have to get rid of that northern access? And see, that's the problem though, because we can't deny access to a property, right? That's the city's point. That's where it gets sticky. Is that right?
Yes, that's correct.
So do you see what I'm saying? We can't, it's hard for us, because remember the annexation, the DA sort of lasts forever unless we condition it based on the use. So it's hard for us to say you change the use of a parcel, so we're going to close your access and make you take access from a different property, which you may not even own anymore. You know what I'm saying? Is that making sense?
It does. And I think Sabrina's comment about other uses and protecting that is valid. I guess the consideration is we're obligating access from a separate parcel to this parcel. So the concern you just expressed is being imposed on this current parcel because he happens to own both of them.
Right. Right. At this time, we can do that, but what if they split? That's the problem, I think.
Mhm.
I'll let other people ask
Well,
questions.
that was going to be my next question is why aren't we just talking about both parcels right now? I mean, their proposal here is to only annexing one of these parcels into the city, correct?
That is correct.
So wouldn't it be a little
You
bit,
don't want to pay taxes. on
right, wouldn't it be a little
parcel.
simpler and cleaner? I don't know. You know, I think it would help the discussion if we were talking about both these parcels in this application.
Thank you.
Mhm.
More questions?
Any more questions?
Mr. Chair,
Mr. Mooney.
sorry, I've got too many. This is a pathways question. So for the city, the plan in the Boise Pathways plan is to obviously turn many of these canals into highways for alternative multimodal active transport. But the New York Canal doesn't have anything in this area. It ends just to the north and just to the south. So the question I have is in SBO 3, is the intent, if they're going to put a canal pathway in, is it going to be on the east bank or the west bank of the New York Canal?
Mr. Chair, Commissioner Mooney, my understanding is that if a pathway does come in that location, it would be on that eastern side. And speaking with our comp planning department, they have indicated that currently the intent for circulation on this side is that there's this planned pathway here that could cut through this neighborhood and connect into this bikeway along Lake Hazel, providing access to that signalized intersection so that people can go any direction safely with a crossing.
Okay, great. So we don't need to condition this for an easement on the east side of Mr. Hatch's application.
Mr. Chair, Commissioner Mooney, that's correct. That's the
Thank you.
staff's opinion.
Okay, thanks.
Mr. Chair.
Commissioner Moore.
So if this is only talking about the one parcel, the DA is requiring access that's all off of the parcel. So technically, this parcel doesn't really have access the way it's written in the DA. Is that correct?
Mr. Chair, Commissioner Moore, that's correct. The access to the site would be provided through that shared access on the adjacent parcel.
And then, Mr. Chair,
Yeah, please.
unrelated question. So is the site plan included as part of the DA?
Mr. Chair, Commissioner Moore, it is not. The development agreement doesn't tie the applicant to this conceptual plan or to the site that was proposed.
Okay. And Mr. Chair, so the main concern is it's showing what kind of looks like vehicle storage, but I see on the DA that offsite parking is one of the restricted uses. And how, in the city's eyes, I guess, how are those two different uses?
Yeah, Mr. Chair, Commissioner Moore, those uses are separate. The offsite accessory parking lot is typically associated with a commercial use that then has a separate parking lot on a different parcel. And that is a use that's outright allowed in the C2 zone. This self-storage use is a bit different. It's a conditional use. So we do have the opportunity to go in and add any conditions for mitigation of any negative impacts that we foresee. So I think those are the main differences.
Thank you.
Okay. Clear, good. Okay, all right.
Thank you.
Thank you. We'll go ahead and open up public testimony. No one is with us online. Got one individual in person. Great.
Good evening, Commissioners. My name is Craig McLeod, 6840 South Cole Road. I'm also the owner of 6780 South Cole Road. I'm speaking on behalf of local residents. They sent me the emails regarding their testimony to the self-storage facility. First one is from David Johannick, and he lives at 4104 South Her Lane. and it's in Boise, 83706. I wholeheartedly support the construction of storage units at Cole and Lake Hazel. I live in Boise and know firsthand the difficulty in finding affordable and secure units to rent. It is becoming more and more difficult with the growth in the valley. I urge you to approve and begin construction immediately. If you have questions or concerns, please contact me. The next one is from Amy Albright. Her address is 7025 West Delaware Drive. To whom it may concern, I'm writing this email in support of her storage facility be in place at corner of Lake Hazel and Cole Roads. The intersection is high in traffic area, and with the new neighborhoods currently being built, there's very likely need of storage units. Those of us that live on this side of town appreciate a close proximity to access to Lucky Peak and recreational activities. Having additional storage for our hobbies and recreational vehicles is greatly needed. Specifically in neighborhoods that are built with extra space for those toys, a storage facility nearby would be an extra bonus. Thank you for your consideration. Next one is from Julian Clark, 2717 North Maple Grove Road, Boise, Idaho, 83704. Hello, my name is Julian Clark. I've lived in Boise for over 20 years and own a power sport and rental business, AJ's Adventure and RV. We have been in high demand of a storage facility in the valley for our personal rental equipment. Our family also owns Snow Cone Shack's business Iced, in which we in need of a store facility that can store our items over the winter. After knowing Mr. McLeod for over 13 years, he has discussed his storage plans with us. We highly support Mr. McLeod's plans as it would greatly help improve such needed storage for our business and personal use. We have desperately searched for a storage facility in the valley that could support our needs. Mr. McLeod would be the first person we would go to for such needs. He has a remarkable reputation for not for helping others, but also doing a great job in all his endeavors, putting others' needs before his own. And I'll take any questions if.
Can't do that now. Just your testimony.
Okay, thank you for your time, Commissioners.
Thank you. Okay. Okay, we'll bring this, you get time for rebuttal, but there's no one to rebut. So I assume you're going to yield that time. Mr. Hatch. Use what, nothing to rebut. No, you don't want to use your rebuttal time at all? Glad I asked.
Chairman Schaefer and fellow commissioners. Thank you again for your consideration this evening of this application and annexation. I think in general, the DA were in support of. It's really just the question about the access. I think Sabrina's been excellent to work with. I think she has some valid concerns, as do the commissioners. So, we still have to do a couple other entitlement processes, and we'll probably be back in front of this commission again. That may be in a more appropriate time to discuss access. That would be another way to, potentially look at that. It's just weird to require it on a separate piece of property. But with that, if you do have any other questions, I'm here. But otherwise, thank you.
Okay, thank you. All right, we'll bring this back before the commission, CAR 21-32. And just a reminder that we are recommending City Council on this motion.
Mr. Chair.
Commissioner Mooney.
I move that we recommend approval of CR 21-00032 with an additional condition on the development standards, paragraph 4A, vehicular access, in plain language as specified by the applicant, i.e. front onto that single parcel, rather than encumbering the one to the south that isn't being considered for annexation, but also including in that note the use standards. And if there's more intensive use coming in the future, that would be, would not be allowed.
Do I hear a second?
Just a point of order, Mr. Chair, if Commissioner Mooney, could you just clarify what you're looking for in your, in the further condition there?
Further condition is speaking to Commissioner Gillespie's point about that northern access is going to be, is good for a low impact use as proposed here. But if the use changes and becomes more intensive, then that access point could be closed off.
Thank you.
Okay, I still don't have a second.
Mr. Chair, for the sake of discussion, I will second the motion.
Okay, very good. I got a second from Commissioner Danley. All right. Who's up? You want to start us off, John?
Sure.
Okay.
I think basically it's everything in the staff report is I'm in agreement with, and with the exception of this access issue. So I was just trying to work around that on the DA and get to a northern access only because of the limited traffic that this use is going to generate.
Okay.
Mr. Chair.
Mr. Oh, we'll go, Mr.
Chairman, so I guess I want to ask Crystal in the city if we can craft a DA that basically gives the city the flexibility to close that northern access point if the use changes, even if it's an allowed use in the zone. Could the DA be conditioned based on a use?
I believe DA could be, sorry.
I think so. Right.
Commissioner Gillespie,
Okay.
yes, I believe so. I
All
would,
So
you guys that married.
We might,
Mr. Chairman.
yeah.
So did you get enough verbiage to understand what we're trying to do? So we're going to want to allow that northern access at, I think it's located 375 feet south of Lake Hazel Road. So it's the one the applicant was proposing. But if the use changes on this annex parcel, then the city has a right to go back and say no, or you got to, or ACHD actually has the right to go back and close that.
Mr. Chair, Commissioner Gillespie, my only question with that is we're not looking at the use right now. So to tie it to that, we could tie it to that use and then state that if there's a change, then we'll relook at access.
Yeah. In the DA, yeah. Are you willing to commit to that use in the DA? So he says yes. Okay.
Okay.
So I'll support the motion then.
Okay.
Mr. Chair.
Okay. Yeah. You read my mind, Mary.
This is legal, Mary Grant. Just for the record, confirming what staff, the question posed to staff as to whether or not a DA can be conditioned based on use, and I would just confirm the response.
Okay. So we're good. Okay. Thank you, Mary. All right. Commissioner Moore.
Not to overcomplicate, would it be better to tie it to the future site plan? That way it's tied to whatever use it ends up being.
That might be legal, Mary. Do you want the site plan tied to the DA?
I might clarify with staff. My understanding right now is that the site plan is not what is before the commission. So tying it to the annexation and the options available to the commission as far as how to condition that annexation would be more appropriate than tying it to a site plan that, if staff could confirm, is not technically before the commission this evening.
Mr. Chair, Commissioner, I agree with Mary's interpretation.
Fair enough.
Mr. Chair.
Commissioner Danley.
So okay, I will not be in supportive of the motion at this point in time, because to me, the cat's out of the bag. We know what is intended to happen in this spot. And if we zone it the way that's being asked, then the next step would be for the very thing we're seeing to come before us, in which case denying it isn't really a possibility. So here's where I land on this. As an annexation in particular, an annexation is something that we take everything very seriously. But in this case, Lupa tells us highest and best use, urban development and within our city parameters, right? Our comp plan suggests that we should be developing in a way that, again, maximizes and optimizes the limited land that we have. ACHD just improved this intersection to the tune of multiples of millions of dollars. And in my opinion, as a planner, I look at this and say, basically, we're looking at annexing and zoning this in a way that allows a parking lot. That's what it is. It's a storage area that is a parking lot, seasonally, even so much so. And while I recognize that maybe there's some folks out there that might feel that as a need, I don't think that our obligation as a P&Z for the city and recommending to city council is one that we should be suggesting that this be approved and be pulled into the city as part of our property. So because we've already seen what is going to be proposed here, to me, again, the cat's sort of out of the bag. If we moved ahead and said, yes, let's move ahead and zone it, we can annex it and zone it and have a DA, but let's forget what we saw. I don't know how we can do that.
Mr. Chairman.
Commissioner Gillespie.
So I understand what Chris is saying. I just don't think this is the right process for doing that. I think we have C2 property in the city. I think it's reasonable to bring this in as C2. I don't think this is the right place to stand on some abstract principles of land use. That the city wants to bring it in as C2. The guy wants to build storage units there, and they're there for 5-10 years, and then the economic pressures encourage him to redevelop it as multifamily housing or whatever, then so be it. Then, putting storage sheds up there isn't the end of the world. They might be there 5 years. They might be there 10 years. He might come back and change his mind and say, I want to put something else in there. So I'm okay moving ahead with the annexation with the DA as we've described it, because it deals with that access issue. And I'll let the market work out what goes there. I don't think it's my job to adjudicate, very specific uses in this case.
Okay. All right. We're going to go ahead and call the roll then. This is CAR 21-32 annexation. We have a motion to approve by Commissioner Mooney with amending language to the development agreement, section 4A, as noted in his testimony. And we have a second from Commissioner Danley. Clerk, that's kind of, clerk, please call the roll.
Schaefer,
Yes.
Squires,
Yes.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Stanley,
No.
Mooney.
Aye.
6 in favor, 1 opposed, motion carries.
Okay, great. Thanks. All right. And last but not least, item number 12, CAA 22-26, Daniel J. Hutchinson, Robert Hathaway, 411 North Hillview Drive. This is an appeal of the planning director's approval to construct an accessory dwelling unit on 0.17 acres in an R1C zone. And we're here from staff first, Mr. Matt Dennis.
Good evening. Mr. Chair, members of the commission. Before you is an appeal of the planning director's approval of an administrative level application for the removal of an existing detached single car garage and the construction of a new accessory dwelling unit in its place. The project site is 0.172 acres located at 411 North Hillview Drive in an R1C zone. On March 22nd, 2022, the planning director approved an administrative level application for the removal of an existing detached single-car garage and its replacement of a new accessory dwelling unit. On March 31st, 2022, an appeal was received and filed by the respective neighbors. The appeal points are summarized on your screen. The planning team has reviewed these concerns and have found that all of these issues have been addressed and conditioned in the original administrative approval. In conclusion, staff recommends denial of the appeal and upholding the planning director's approval. I will stand for questions.
Okay, great. Thanks, Matt. Next, we'll hear from the appellant.
Good evening. I'm Daniel J. Hutchison, live at 102 North Jantoni Drive, Boise, Idaho, 83712. As was noted by your staff, the appeal that I submitted was the administrative approval of the removal of a single car garage and the construction of a accessory dwelling unit on a single residential family lot. I need to note here before we go any further in this meeting that the first part of that appeal was for the removal of the garage. That garage has been removed prior to this hearing tonight and prior to any resolution of the appeal that was applied. Now, I do address that it is incompatible with the existing zoning. The area to the east of North Costin Drive on the east end of Boise has been one of the stable single-family residential neighborhoods for the 75 years since it was formed. Since 1946, when the subdivision was approved, all of the various city zoning codes have continued to call these single-family residential lots. In the education that I received, and I was a professional anthropologist, have seen worldwide, there's a difference in the way numbers. One means one, single. Multiple means two or more. This is a single family lot, and the proposal is to set a second dwelling on the same lot that changes it, in my view, into a multiple family lot rather than a single family. Now, with the Boise City Code, there's a minimum lot size for each dwelling. The lot size in the neighborhood there east of North Costin Drive and in the Warm Springs Park neighborhood are not large enough to allow for a subdivision of that lot into two separate lots. Even though under the proposal, they're proposing a separate dwelling, not connected to the existing one, separate water, separate sewer, separate electrical. Again, that makes a difference between one and two. We're talking about changing the existing structure of the neighborhood. Now, we also need to look at accessory dwellings as temporary dwellings that are incompatible with a stable, comfortable, single-family residential neighborhood. With the deed restrictions that would be applied that require the landowner to live on the property or to have the accessory dwelling removed, would add both definition of that as a temporary dwelling or a temporary structure being used as a residence. It would also place a heavy burden on the neighborhood for keeping track of who owned the property, who was residing on the property, and then taking the civil action to force the removal of the property. And anytime you start destructing or tearing down properties in a residential neighborhood, it disrupts the stability of the neighborhood. Also, with the movement that we see nationwide with these accessory dwellings, one of the most common things that are advertised by the developers of these, not only in Boise, but elsewhere, is their potential use for commercial short-term rental properties that can provide a lot higher income return on the property than a single-family residential rental might be. And commercial use in a single-family residential neighborhood is not compatible. Also want to comment on the insufficient involvement of the community in major decisions such as this. The planning staff received the application, took 19 days before they approved the project with no contact with the community surrounding it, other than the neighbors that had immediately adjoined the property. After the approval was made, with no opportunity to have input into the design or appropriateness of the project, we were given 10 days to appeal it. But the notification of the opportunity to appeal was only sent to those of us that lived within 300 feet of the property. So within that very limited 10 days, we had to make contact with the other neighbors, research the type of project that was being proposed, develop our position on whether we opposed it or not, and submit the appeal. The Planning Commission now has had 67 days to look over the appeal. That has placed I think, unreasonable burden on the ones of us that want to protect the stability of our neighborhoods, and places it very heavily weighed onto those that want to infringe the neighborhoods and extract value that they can use for their personal gain at the price against their neighbors. We also need to know that need to remember that the Boise City is in the current process of looking and rewriting the city zoning codes. And one of the issues that is included in that is the continuation of the process of changing by administrative wording, single family to multiple family, by using a fancy term, accessory dwelling, rather than multiple family, in which it really is. I don't think we should be approving any accessory dwellings in the stable single family residential neighborhoods until the adequate public review and process and comment and consideration is given throughout the community, and this Boise's code rewrite is completed. Now, we all know that the original intent of planning and zoning was to get the community involved in helping stabilize residential neighborhoods. So what I'm asking you folks to do tonight is to fulfill your obligation to help stabilize neighborhoods, not disrupt the neighborhoods, approve my appeal and deny the project that's being proposed to introduce multiple family housing into a single family neighborhood. With that, thank you.
Okay, thank you. Okay, next we'll hear from the applicant.
Mr. Chair, members of the commission, thank you for your willingness to take this up and for your endurance. We really appreciate it. This will be straightforward and to the point. This board must deny this appeal.
Sorry, I hate to stop you. I need your name and address for the record.
Preston Rutter with the law firm Clark Wardle, address 251 East Front Street, Suite 310 in Boise, Idaho.
Great, thank you.
Thank you. This appeal, it must be denied because it attacks a non-discretionary ministerial act. And what I mean by that is if we check the criteria, which our code is expressly provided, there's no discretion. You had the discretion tonight to whether extend this meeting to allow us to be here. However, when this application came through, all the check boxes were marked and there was no discretion in that. And rightfully so, on March 22nd, the planning director through his designee approved this. Boise City Code provides 10 criteria. The applicants here have satisfied all of that. And the objection you heard tonight is about personal policy preferences, the shape, the feel, the tenor, the tone of the neighborhood. That is not what we're here on tonight. The appeal is whether the criteria was met or not. It has been met through the first application on March 22nd, and it should be upheld tonight. The appeal must be denied. The criteria is city code It's not policy. This forum is an appeal. The objections that have been raised would be better suited for a forum when the zoning code is on the table. That'd be a wonderful place to discuss the policy ideas, but not here, not tonight. Only city code controls. Even if policy applied, our policy prevails. We have a quality housing option that's being provided in our community, and Boise needs quality housing. The applicants have been wonderful through this process. They have extended an olive branch to the concerned neighbors, including the appellant, Mr. Hutchinson. They invited him to their home. They visited with him and tried to hear out all the concerns like we are tonight. But we're not here to appeal to policy concerns. We are here to follow code. And if I may address some of the other matters that were raised by appellant, he takes issue with the removal of the garage. The appeal is for an accessory dwelling unit, the construction of it, not the removal of a garage, which they could have done without coming before this body. The term single that's used in single family residence, our code allows for accessory dwelling units within that single family residence zone, R1C. There is no minimum lot size to accessory dwelling units. That's a moot issue that was raised. And these are not temporary dwelling units. As noted in your packet, the applicants are going to sign upon approval or upholding this decision, a deed restriction that at least one of the residents has to be occupied by a owner. What's interesting is before this application, the owner doesn't have to live there. They could live in Massachusetts and rent this house out. But because of this application, they are willingly signing a deed restriction requiring the owner to be there. So we're keeping people in our community by virtue of passing this. And there's no heavy burden on the neighborhood to enforce these deed restrictions. The potential use are not commercial. Obviously, we're here for code criteria, but a little context, if it's of interest to you, this accessory dwelling unit is going to be for an aging parent, and she will reside there and live out the rest of her life peacefully. There is already built into our code protections for commercial uses, so that concern is moot. And the notice of due process and procedure has been followed in full 100%. And there can be no violation of that due process. We followed it. And lastly, the code that was on the books when the application came in, that is the applicable code. We cannot reach into the future for speculation on what is proposed code discussion about it. We just cannot. This body is barred from that. They have a vested right, the applicants, as of the time the application came through. And the code at that time, they check every box, and they're going to double check it again tonight, and it should be approved. And the appeal must be denied for that reason. I'll stand for any questions. Thank you.
Okay, thank you. Okay. I don't think we have anybody from the neighborhood association with us. Okay. Go ahead and open up questions. Go ahead and open this up for questions from the commission to staff or the appellant or the applicant. We gotta throw Matt at least a couple of questions. Come on, it's his first one. Okay. All right, no takers. All right. Okay, we'll just keep on moving then right to public testimony. Open this up for anybody that wants to testify. No more takers. Okay, so now we're to a point where we typically get to go to rebuttal. Guess we'll go ahead and do that. So we'll do a rebuttal from the applicant first, and then we'll do the appellant. So Mr. Rudder, if you have anything you want to add in rebuttal, you got a couple minutes for that.
There's always one or two things to save. This appeal really is just dragging this out. Is utilizing the appeal process to drag out an of right approval. And this is not a discretionary decision. And this is delaying the applicants from pulling a building permit. They are ready to turn dirt and get this built. Thank you.
Yeah, thank you. All right, and now the appellant, Mr. Hutchinson, your turn to rebut.
Yes, the main point I want to make is it does put a burden on the community and the neighbors to enforce deed restrictions. There's no structure within the city Boise code, the city Boise legal department or code enforcement to check on deed restrictions. That's a civil matter between the people that own the property and that have the deed restriction and the adjoining neighbors or people in the community that are willing to keep track of that and enforce it. We see that throughout the community with the neighborhood associations in the various neighborhoods, that as long as the neighborhood association is active in enforcing the code or deed restrictions, the deed restrictions are followed. Once the neighborhood loses interest in maintaining their neighborhood association in deed restrictions, then they fall out of use and care. And then when you do try to enforce them, the defense is, well, nobody's paid any attention to it for 3, 4, 5, 20, 30 years. And so it becomes non-enforceable, such as the original deed restrictions for the neighborhood talked about every dwelling needed to cost at least $4,000. It's not too hard to comply with that these days, but it shows how deed restrictions with age become non-enforceable, other than the burden on the neighborhood to keep it up. So I would again appeal to you to approve the appeal and to deny the construction of accessory dwelling, and to not reward people that proceeded with a project that was under appeal before the appeal process was played out and you were able to hear the full nature of the project without commitments that it's already underway. So thank you for your time tonight.
Okay, thank you. Okay, we'll bring this back before the commission to render a decision. CAA 22-26.
Mr. Chair.
Commissioner Blanchard.
I move that we deny the appeal CAA 22-26.
Second.
Got a motion to deny the appeal and a second. I'm sorry, a motion from Commissioner Blanchard and appeal from Commissioner Squires. Commissioner Blanchard, do you want to start us off on discussion?
Absolutely. Well, thanks everybody for staying so late for this. But so just to address a couple things, Mr. Hutchison, we had these discussions on ADUs in 2018 and 2019 from a policy perspective, and that was when we amended the code to allow ADUs in R1 zones. So that ship sailed a long time ago. So to the second point, then we have absolutely zero legal ground to grant this appeal, none, because it's in code as the attorney described it. This is by right. I mean, you're trying to argue that this thing that they can do by right in the code should be appealed, and it's just there. We literally have no way to do that. So we can only judge this appeal on the current code and not what might happen with the future zoning code. But I will just tell you, that's another, if you're interested in that issue, that's another ship that has sailed. Single family R1 zoning is going away across the country. It will not exist it won't exist in 5 years in the city of Boise. It won't exist by the time this code is done. So that's my crystal ball for you. But this single family zoning, as you understand it, where you can only have one residence, that is going away across the country. So I would not expect that you'll see any change to that coming up with the new zoning code. So anyways, just summary, we don't have any legal ground to grant this appeal.
Mr. Chair.
Commissioner Squires.
I'll just echo what Commissioner Blanchard said. They meet all the requirements of this. We have absolutely no ability to grant your appeal, absolutely none. And as far as them removing their garage, it's private property. They can go do whatever they want on their own property as long as they get the appropriate permits, if deemed necessary. Again, residential is compatible with residential. That's all I have to say about this. And I will be supporting the denial.
Okay, Any other comments? All right. We've got a motion to deny the appeal of CAA 22-26. Motion was by Commissioner Blanchard, second by Commissioner Squires. Will the clerk please call the roll?
Schaefer,
Yes.
Squires,
Aye.
Blanchard,
Aye.
Moore,
Aye.
Gillespie,
Yes.
Stanley,
Aye.
Mooney,
Aye.
all in favor, motion carries.
Okay. Thank you all. We're adjourned.